Okay, so before going to the questions, every year you must be knowing that there are some 16, 17, 18 or 22, 25 questions from polity. Okay, it can range from 15 to 20s. Fine. So you should be very much careful that you should not make any mistakes in polity. But there is a trend from I think 2020 onwards. There some of the questions are being asked which are not from polity, this Lakshmikant, but some current affairs like judicial custody, what happens at at that time, and so many questions are there. So those are linked to the current. Okay, so you should not feel that के like लक्ष्मीकांत पे तो ये है ही नहीं, ठीक है, वैसा नहीं होना चाहिए, because you have to do लक्ष्मीकांत, चाहे उसे आए नहीं आए, मतलब ऐसा नहीं है कि किसी साल आपको लगा कि लक्ष्मीकांत का उतना नहीं आ रहा है, तो वो तो जो भी आ रहे हैं that will be directly from current, इसलिए उसके लिए you don't need to worry. लक्ष्मीकांत से कुछ आए वो आपको गलत नहीं होना चाहिए. This is my point. Okay, so this is 2021 paper. In 2022, there were questions from the other parts of the polity, not the initial first 5 chapters. Okay, so in 2021 we will see some of the questions, in 19 also, in 20 also, 18 also. So only in 2022 there were some questions which were from the other chapters, not from initial 4-5 chapters. Okay, so you will give me the answer. Okay, you will type in the chat box. So this is this we'll do today. This also we'll do today. Now you tell me this. We have read this, okay? What was the exact constitutional status of India on 26 Jan 1950? Please answer me. Prafulla, I'll answer this question later. Huh? Let's focus on the MCQ right now. Okay, just answer me and I'll tell you at the end of the class. Okay, B. Okay, so the answer is B. Why B? Because at the time of on 26 Jan 1950, we had the Sovereign Democratic Republic. Then SSI was introduced later through 42nd Amendment Act. Hai na? This we did. Okay, this is the sovereign, socialist, secular, and integrity word. So this was added later. So you know this. Now, what do you mean by constitutional government? Okay, Rohit D, Shubham D. Okay, others. Okay, so everybody is saying D. Okay, and this is correct. So what is constitution? Why constitution? Because constitution has provided some of the limitations on government, on the tyranny of the government cannot assume the arbitrary powers. Hai na? Everybody, we have the separation of powers and we have limitations on the powers of every organ of the government. Okay, so this is the correct option. And this question is repeated again and again. This was repeated in, I think we will see in 2019 also. Okay, same question. Then this also we will do today. Yeah. So this question you have to check the best option available. Okay. The direct, ऐसा नहीं कि directly लक्ष्मीकांत से है, directly नहीं है, but indirectly है. So just answer this. Okay. A. What about others? Okay. ठीक है. Okay. So the correct answer is A. Why? Because if you check the 4 options available, ठीक है, you have to check the best among all. ठीक है, सबसे अच्छा कौन, सबसे सही कौन है, ठीक है. So the independence of judiciary is safeguarded. How can you defend this? Because what is federal? Federal means that you have some powers with the center, some powers with the state, and now since we have 3-tier government, so there will be local government also. Now, who will ensure this? That center is not overriding its powers, or state is not going into the center's domain. So the judiciary will ensure this. Okay, so now when judiciary is independent, when judiciary is supreme in their own affair, it's not that they are sovereign, like they have unlimited powers. ऐसा नहीं है, ठीक है. But if the judiciary is independent, if the judiciary is having the powers to check on the arbitrariness of the center or the state, then definitely we can have the federal character of our system. Okay. So this is correct. This we will do today. So see, initial chapters are so important. मतलब जो आज का lecture है वहां से कितने questions आए हैं. So this we will do today. The above questions we will do today. ठीक है. Citizenship we will do today. Don't worry about this. And yeah. So which of the following factors constitutes the best safeguard of liberty in a federal, in a liberal democracy? Again, you have to see the best option. Which factor will safeguard the liberty? ठीक है. A. No. This is a negative thing. You should not have committed bureaucracy, committed judiciary, or committed in the sense that they have some political tinge. Okay? If separation of powers is there and that separation of powers is upheld, okay, and then there is this independence of judiciary, then only you can a sort of guarantee what the liberty. Only then you can guarantee the federal structure जो ऊपर देखा, ठीक है, federalism, secularism, liberty, equality, justice, all these things will be there when you have separation of powers, when you have independence of judiciary, when you have balance of powers. ऐसा नहीं कि कोई particular organ of the government will usurp the other organs of the government. ठीक है, वैसा नहीं होना चाहिए. ठीक है. So this is directly from Lakshmikant. We just discussed these 2 points yesterday. Please answer me. Riya, C, Prachi, C, Shubham. Okay. Others? Pratham? Okay. So this is the correct option. Why? Firstly, because we know that Britain Parliament is sovereign, Indian Parliament is not, because we have separation of powers, okay, and people are supreme, है ना? We the people of India. Then in India, the matters related to the constitutionality of amendment of an act. So we know that the power, the judiciary has the power of judicial review, है ना? That also we will do today. So because of this power, judiciary has the power to see whether the amendment made by the legislature are the amendment is in accordance with the constitution. If it is not, then obviously that will be declared as unconstitutional and void. If it is if it is not in violation, then it will be upheld as constitutional. So both the options are correct. So this we will today do today. Okay. Then this is which year? The 2020. Okay. Fundamental rights we'll do today. Yeah, see, this is again the same question has been asked, 2020 and 2021. Okay. Normal bench cannot, for constitutionality, you should have at least 5 judges in the bench. Only then you can establish the constitutionality. Okay, this we will do in judiciary, don't worry. So this is the repetition, है ना? You know, the limited government is the correct option. So fundamental rights we'll do today. And okay, what is parliamentary system of government is one in which? You have to see the best option. ठीक है, कभी ऐसा हो सकता है कि there can be 2 options which are very near. ठीक है, but then among the 2 you have to see the best. Okay, so which one is the best? So maximum majority of the people are saying B. So the government is responsible. Yesterday also I told you, whenever you see the parliamentary word, the responsibility should come to your mind. Okay, so the government is responsible to the parliament and can be removed by it. Why? Because we have the dissolution of this lower house. And I told you to remember those 6 points if you can recall right now. So First was that it was a responsible government, then there was a majority party rule, then there is the ministers are the members of the parliament also. Then one of the point was the dissolution of lower house. Okay. So it is nothing but the same point. Okay. So this we will do today, the DPSP. Now preamble. So now tell me this. Okay, D. Profula C. No. We read this ना, ये बिल्कुल मतलब बिल्कुल लक्ष्मीकांत पे दिया है, कल ही पढ़ा था. ठीक है. So why is the option D correct? Because this is a part of constitution, we know, है ना? There are so many cases, like there was first Birubadi, then Keshananda Bharati, then LIC case. Apart from this, these two said that this is a part of constitution, है ना? We did this. Now, no legal effect independent of others. So you cannot go to the court and say that preamble says that we are all equal, है ना? Only on the basis of preamble you cannot approach to the court. ठीक है. You can go to the court because there are other constitutional articles. So on the basis of those articles along with the preamble, ठीक है. Individually आप नहीं जा सकते हो court by saying that preamble की वजह से, you know, I enjoy liberty, equality, fraternity. No, there are some constitutional provisions. On the basis of those provisions clubbed with the preamble, only then it can have the legal effect. ठीक है. So these are the 2 years question papers. Next we will see the others also. So this I was talking about yesterday. Okay, this will be the last question because we have to take the today's class also. So tell me the definition of liberty. I told you that there are 2 conflicting options in this. Now you have to check the best among the 4. Okay. Fine. So you are saying that option D is correct. है ना? Right. I told you yesterday also. So why is this correct and why is this not correct? Because I told you this was the earlier concept. Okay. This was the earlier concept. The absence of restraint means liberty. But this absence of restraint, it was sort of vague. कि क्या है restraint? कि कितना मतलब absence of restraint? ठीक है. To what extent? Then the best definition chosen now in the contemporary times is the opportunity to develop oneself fully. ठीक है. That will be considered as the meaning of liberty. ठीक है. So with this, now you can understand whatever is asked is within the Lakshmikant only. If you are clear with your concept, then you can attempt these questions. ठीक है. So let's discuss the today's class. Okay. So we stopped at chapter 5. So I'll quickly recap the initial articles. ठीक है, because there was some network error yesterday. So let's begin. Doubts I'll take at the end. So just focus whatever you have, any problem that we will discuss at the end. Okay. So this is a chapter 5 now. And this is about the union and its territories. Okay. So it will talk about article 1, 2, 3, 4, and then we will see what others topics are there in the chapter. So what is article 1? It simply means you have to remember the definition simply. So on the basis of this definition, you can directly answer the question. Okay. So if you are well versed with these articles, what article 1 is, what article 2 is, 3, 4, 5, and the other important articles that we will do, obviously. So you can answer any question, trust me. So polity, you should be at least very, you should have a very strong hold on polity. Okay. So India, that is Bharat, is the union of states. Yesterday, I also told you that we are using the word union and not the federation because of these 2 provisions. Okay, because of these 2 reasons. What the reason is, firstly, we are not union by means of the agreement, but this is the general, we have just consolidated all the parts of India and we came up with a union. There is no agreement, no terms and conditions. Then no right to secede also. No state can say, suppose now the Nagaland is demanding the greater Nagaland. We cannot say, okay, you take your greater Nagaland. ठीक है. They don't have right to secede. Okay. So their demands will be if the government feels, if the parliament feels that their demands are within the constitution, and we can fulfill their demands by protecting the unity, sovereignty and integrity of nation, then only we can do that. Otherwise, there is no right to secede. Okay. Now, under Article 1, this territory has some meaning. So what is the meaning of the territory? Firstly, it means the territory of state. Then it means the territory of UTs. Then it also means some other territory which government of India may acquire at any time. ठीक है, जैसे we acquired so many territories which were earlier with the Portuguese or which were earlier with the French establishment. ठीक है, we acquired those, so those became the parts of the India. So I told you yesterday also, tomorrow we can go for the POK, है ना, and can acquire that, and that will become the territory of India. So we can do that because we are sovereign nation. Then there is first schedule also that is in consonance with this Article 1. Why? Because it talks about the names of the states and the UTs and the territorial extent. Like this state has a territory up to this limit. Okay, everything is written in the first schedule. Okay, now this territory, I told you, this is a wider expression. Why? Because Union of India, whenever we talk of Union of India, it takes only the state. Okay, not the UTs and etc. Or these parts that we may acquire. Okay, so this territory has a wider connotation than the word union. You should know this. This can be asked as a statement, whether territory has a wider connotation or the union has a wider connotation. You should know only this much. Okay, detail में जाने की जरूरत नहीं है. उसके बाद how can you acquire the foreign territories? Now we are saying that we can, but how can we do that? We can do that only by the international law. ठीक है, it should be obviously nobody should come and criticize India for acquiring territories, because acquiring territory is not that easy. ठीक है, but we can do under these three conditions. Firstly, the session can happen by means of some treaty. Suppose Pakistan और India के बीच में कल को treaty sign हो गई, and Pakistan is saying, okay, you can take POK, no problem. Instead of POK, give us something. Suppose give us the entire control over Indus, for example. Some treaty is there. Okay, this is some imaginary concept. Okay, or we are purchasing something. For example, we are some island is there and we want to purchase that. We can do that and we can acquire that also. Okay, so or by gift, lease, plebiscite, we can do any of these. Okay, then by occupation, there can be some occupation also, that will be also under some international guidelines. ऐसा नहीं है कि arbitrarily हो जाए. ठीक है, so we have to take care of the international conventions and laws also. Then the conquest or the subjugation, this we have already done, है ना? For example, Dadar and Nagar Haveli, Goa, Pondicherry and Sikkim, all these territories we have acquired, we have subjugated. ठीक है, at that time. So these are the three ways by which we could do this. Okay, this is as per the international law. Now there is Article 2 and Article 3. Article 3 is simply for those which are the existing states, and Article 2 is for those states which are not a part of India right now, but we want to admit them into the Union of India. ठीक है, in that case only. And who will do this? Parliament. So at the most, if a statement is asked in the UPSC, they will ask you, Parliament can, ठीक है, Parliament can or may admit into the Union of India or establish new states, ठीक है, on some terms, on conditions, ठीक है, whatever Parliament comes up with, which are not the parts of the Union of India, okay, which are currently not the BATA, but we want to acquire them. Suppose Sikkim was there, ठीक है, that was acquired later on. It was initially not the power under the India, ठीक है, that we can do. So we have some Parliament can come up with some provision and Parliament can do it. But this is not for UTs. For UTs, we do the Constitutional Amendment Act, ठीक है, that is a separate thing. This is only for the states. Then what is Article 3? Article 3 talks about the formation. This is simply the internal adjustment. I told you yesterday also. Just remember the word internal adjustment for Article 3. If you are going to increase, decrease the area or changing the name or doing whatever within the map of the India, so that will be under Article 3 simply. And who will do this? Parliament will do this. These are the points that you have to remember. Then there are two conditions, because you are ultimately tampering with the states only, है ना? You are increasing their area, you are decreasing their area, you are changing the boundary, name, whatever. So then what is the condition is the president we have to acquire the prior recommendation of the president, number one. Number two, the president will then send this proposal to the state legislature for expressing the view, just to express the view. What do you say? Okay, president will ask the state, what do you say about if we change your name to this, from this to this? ठीक है, then state can give its view that may or may not be accepted by the president. ठीक है, this is just a formality. ऐसा नहीं है कि state will say that we don't want to change our name, then president will say okay we won't. ऐसा नहीं है, president can either accept or reject it. ठीक है, it depends on the parliament only. Then so we can say in total we can say Article 3 is about the parliament can redraw the political map of India, ठीक है, without the state's consent. Just one thing is to be done, that is we have to inform them. बस inform कर दो, बाकी कुछ करने की जरूरत नहीं है. Therefore it's rightly said that India is indestructible union of destructible states. ठीक है, we can destroy states, we can cut, we can increase the area, we can decrease the area, we can do whatever we want. ठीक है, we in the sense the parliament. ठीक है. So the territorial integrity of states is not guaranteed. Only the territorial integrity of India is guaranteed. ठीक है, India is what? Sovereign. ठीक है, इसकी boundaries cannot be changed, cannot be tampered, nothing can be done. But with states we can play. Depends in the national security, in the name of the public interest or national interest or national security, we can change the political map of India. ठीक है. Then you have Article 4. What is Article 4 is? Simply just remember one thing within Article 4, the whatever you do within Article 2 and Article 3, ठीक है, that won't be considered as an amendment under Article 368. That will be a simple amendment. ठीक है, that can be done by simple majority, but that won't be considered as amendment within the purpose of Article 368. ठीक है, बस इतना काफी है, इससे ज्यादा won't be asked from Article 4. Now, so does that mean that does power under Article 3 also include a power to cede, है ना, Indian territory to the foreign nation? So yesterday also I told you that we are sovereign, therefore we can cede any part if we want, we can cede. ठीक है, why? Because we are sovereign. But that will be done only under Article 368. Okay, so we have to come up with the Constitution Amendment Act. We will amend the Constitution and then we can cede some part to the other territory like Viruveri Union was done. ठीक है, so Article 3 does not cover cession. So cession इसमें नहीं आएगा. Article 3 just talks about whatever is within the boundary of India. ठीक है, so ceding the territory to some other nation, that for that we have to do the amendment under Article 368. ठीक है, बस इतना याद रख लेना. Then this is the same thing written in Lakshmikant. ठीक है, so one is boundary dispute, another is boundary dispute, another is the internal adjustment. ठीक है, and the third one is the cession. You should be clear with these three things. For boundary dispute, you just have to go for the executive action. कुछ नहीं करना है, बस executive order लेके आओ. Okay, just the executive order would do. But for internal adjustment, you have to invoke the Article 3 and then there will be simple amendment, constitution amendment outside the Article 368. ठीक है, outside 368. But for session, you have to invoke Article 368. This is the basic difference. ठीक है, you should be clear. This can be asked, this can be asked, this can be asked. Okay, this is Article 368. This is just the executive order. ठीक है, this should be clear to you. Then one second. Yes, like India, Bangladesh. ठीक है, there was 100th Amendment Act because there was some change of enclave also. Therefore, that we needed to invoke the article. Otherwise, we could have done that by executive order also. But since we had some exchange, some enclaves were to be exchanged, so we went for the 100th Amendment Act. ठीक है. Now, the evolution of states. Okay. So you know that already that we had the British provinces, we had the princely states. ठीक है, these were under the direct rule, but these were the princes were directly ruling them, and the princes were directly under the British sovereignty, that we know. Then there was this Independent Act 1947. Then there was creation of India, there was creation of Pakistan, and princely states had been given the choice whether to join the India or Pakistan. So after 552. 549 joined India without any problem. ठीक है, we are Indians, we will join India. But these had some problem. ठीक है, Hyderabad, Junagadh and Kashmir. Okay, they did not want to join India at that time, so they were incorporated. How they were incorporated? इतना याद रखना है बस. कैसे क्या? We don't have to go even in post-independence India. in your main syllabus. We don't go into much of the detail. बस याद रखो कि Hyderabad by police section, Junagadh by referendum, Kashmir by instrument of accession. That's it. Okay. Then in 1950 we had the fourfold classification. ठीक है, all the entire this is the entire map of India which was divided into 4 parts. ठीक है, part A dealt with the governor provinces, part B dealt with the princely states with legislature, okay, earlier the erstwhile. ठीक है, part C dealt with the chief commissioner states. I told you there were some chief commissioner states like 4 है ना, who had the different provisions, like we have the union territories currently, and there were some princely states without legislatures, उनको रखा था part C में. ठीक है, then we had part D that was for Andaman and Nicobar. Simple. This was in 1950, but we know that this was the ad hoc arrangement, तो ये तो हमेशा रहने वाला था नहीं. ठीक है, so there was a demand of reorganization. Now how will we redraw the political map? Okay, so there was, everybody wanted to redraw the map on the basis of language only. ठीक है, so government knew this, government appointed the Dhar commission, and Dhar commission had to check the feasibility whether we can go for this linguistic basis or not. Then in December only, in the same year, the report was submitted. Then the administrative convenience was approved, okay, as the basis for the creation of the states instead of the linguistic factor. नहीं, linguistic factor नहीं चलेगा. We have to go for the administrative convenience. So everybody was, there were revolts, resentment, and things like that. Okay, then there was another commission was appointed, okay, in the same year, in the same month, that is the JVP committee. Okay, JVP committee in the next year submitted its report. It again rejected language. Can language नहीं चलेगा, it will not be feasible. ठीक है, but then there were so much hue and cry, agitation, and the death of the this Sri Ramulu. So because of that thing, the first linguistic state, that is Andhra, was created. So when the Andhra was created, obviously there was a domino effect. Then everybody asked, अगर आंध्रा बनाया तो हमारा क्या, हमारा क्यों नहीं सुन रहे हो? ठीक है, so then it intensified the demand. Okay, then there was this appointment of the Fazal Ali Commission. Fine, and this was the commission. It had the Fazal Ali as the chairman, Vanikar and Kunzu, these were the other members. Might be asked, okay, you should be knowing. Then it said that ठीक है, because there was this so much violence in the country, therefore it accepted the language as a basis of reorganization. But बोला कि one language one nation नहीं चलेगा. ठीक है, one language one state. ठीक है, okay, we will accept language, but ऐसा नहीं कि only one language will be there in one state. ऐसा नहीं है, because it's not possible in India. There is so many languages, so many dialects spoken. So therefore, apart from the language thing, these 4 are the factors which are to be taken into account. And this is asked usually. This is asked in mains also, and this can be asked in prelims also. So you should be knowing these 4 points. ठीक है, firstly, apart from the language, you have to maintain the preservation and you have to strengthen the unity and security of India. ऐसा नहीं है कि आप language के basis पे कर रहे हो and that will create the schism within the society and there is disintegration. Okay, the unity should be preserved, the security should be ensured, then the linguistic cultural homogeneity should be there. ठीक है, if you are, this is a patch, this is a particular state, so it should be homogeneous linguistically as well as culturally. Then the financial, economic and administrative consideration should be there. ठीक है, this is also to be considered. ऐसा नहीं है कि you are creating this part, but they are not economically viable. ठीक है, they won't be able to govern themselves. Possible नहीं है, administration problem होगी, तो वैसा नहीं चलेगा. ठीक है, then the promotion of the welfare of the people. Suppose Telangana was there, है ना, so there was a demand since long that we should be created separately, this and that. So these factors, so all these factors are to be considered before accepting, before any demand is to be accepted by the government. ठीक है, so just remember, apart from the language, these are the 4 factors that we need to consider. And who has given this? The Fazal Ali Commission. So then there was abolition of 4 classification, and then on the basis of these 4 criteria, the 16 states were created, and there were 3 centrally administered territories. ठीक है, so government accepted this. Obviously, this was the best thing that we could do, but certain minor modifications would have been there for the political and the administrative considerations. So there was this important act, the State Reorganization Act of 1956 and 7th Amendment Act of 1950. 1956. ठीक है, both the acts were passed and this was abolished. This whole scheme was abolished. Then we had the 14 states and 6 UTs which were created on this date. This date you should at least have the idea. This was the 1st November 1956. ठीक है, so if you want to see this, this was the earlier scheme. Okay, part A, part B, part C. This was the number of the states that were there. ठीक है, 9, 9, 10 and 1. Okay, then it won't be asked इतना detail में नहीं पूछेगा part A में क्या था, part C में क्या था, but you should have the idea that these 4 existed in 1950. उसके बाद 56 में these were the 14 states and 6 UTs created. Okay, you can just read these. After this there were so many amendment acts for the incorporation, like 15 state कैसे है, 16 कैसे है, 17 कैसे है, till now 28. ठीक है, so now we have 28 states, है ना. So this is up to 14 states we had in 1956. So these things you should know. So what happened after 1956? Let's see. So now, since there was this language criteria and the 4 other factors were to be taken, but then there was still some pressure from the agitations and political conditions. And there are some politics going on in every state. So they demanded more and more states should be created for language and cultural homogeneity. These things should be considered, this and that. So it gave rise to some of the bifurcations. Okay, bifurcations or trifurcations. Let's see. So here I have written that you have to memorize the chronology, है ना? The initial batch that I had. So I remember they had been able to remember the chronology, and I hope they still remember that. ठीक है. Now what happened in 56 तक क्या था? 14 states थी. Now 60. This is the 1960. ठीक है. After the 4 years only, the Maharashtra and Gujarat was created. So this was a bilingual state. Two languages were spoken there. First, the Marathi speaking people were there. Gujarati speaking people were there. ठीक है. So the Gujarat was established as 15. So 14 तक we know. ठीक है. Now which is the 15th state? The Gujarat. ठीक है. Remember this. Then so Portuguese, we know that there were some territories under Portuguese, some territories under France, है ना? That we know. So the Portuguese, they ruled till 1954. After this, the administration was it was carried on till 1961 by an administrator. ठीक है? People used to choose the administrator, but what happened? Then it was converted into the Union territory. ठीक है? By the India. ठीक है? Under the 10th Amendment Act. So this we incorporated within our own territory through this Amendment Act. ठीक है. Then Goa, Daman and Diu, again this was a Portuguese territory. After the police section we incorporated these, and there was a 12th Amendment Act later in 1987. Remember this date because this was asked. I don't know which year, but this was asked. And the chronology was asked. Okay, so the Goa was conferred statehood. This was one of the statement. So if you don't know the date, so you cannot be sure about the answer. Okay, so in 1987, just remember the date and the creation of a state, which state was created when. Okay, 1987 Goa was conferred the statehood. इतना याद रखो. ठीक है. उसके बाद the Puducherry is there. This was again initially the France controlled the Puducherry, Karaikoram, these Mahayanam, etc. Then it was taken by India, okay, as the acquired territory. After this, इतना series you don't have to remember, बस याद रखो कि कब कौन सा बना था. ठीक है. So subsequently you just remember since it was the acquired territory till 1962, then it was made the UT under the 14th Amendment Act. ठीक है. It is the UT. Then what happened? Then for Nagaland, remember in 1963. So it was formed by taking the Naga Hills, this and that. Okay, so it became the 16th state. Okay, so 15 was Gujarat, 16 is the Nagaland, rest were the Union territories. Then for Haryana, Chandigarh and Himachal. So 17th state was the Haryana. Okay, so this is now the 3rd, and this is in 1966. The Punjab was bifurcated. Okay, then there was a Shah Commission appointed. Just remember, Shah Commission was appointed for what? For conferring the Punjab to the Punjabi speaking people and Haryana to the Hindi speaking people. Just remember this is associated with this. Detail में नहीं जाना है. ठीक है. Himachal was the 18th state. इतना काफी है. 15, 16, 17, 18. ठीक है. वहां तक पहुंचे. Now MTM states. What happened there? This date is again important, 1972, because the map of the Northeast was redrawn. ठीक है. काफी changes आई इसमें. So firstly, the two union territories, Manipur and Tripura, and the sub-state. It was not fully state, it was not UT, it was in between the two, the sub-state of Meghalaya. They got the statehood. Okay. So Manipur became the 19th state, Tripura became the 20th, Meghalaya became the 21st. Okay, we reached to till 21st. So you have to remember the chronology. This can be asked. उसके बाद सिक्किम, दिस इज इंपॉर्टेंट, ठीक है. डिटेल में यू विल रीड दिस इन पोस्ट इंडिपेंडेंस, अभी नहीं चाहिए डिटेल, ठीक है. बस इतना याद रखो कब बना था. सो इनिशियली, ठीक है, प्रिंसली स्टेट थी, चोग्याल के अंडर थी. उसके बाद सिक्किम जो है प्रोटेक्टोरेट स्टेट बनी अंडर इंडिया. So its defense, external affairs, communications we were controlling. Then in 1974, it expressed its desire that I want to be that we the people of Sikkim want to be incorporated within the territory of India. ठीक है. Then there were some amendment acts which were passed to give the statehood to the Sikkim. ठीक है. So finally, you don't have to remember this entire thing. It did not last long. After there was this referendum. Okay, just forget this. इतना याद रखो कि finally this was incorporated as the integral part of India. ठीक है. It became the state, and consequently the 36th Amendment Act was enacted to make it a fully fledged state. It became the 22nd state. ठीक है. Then there were some changes made in this schedule, because you have to change the name, you have to change everything. Okay, so obviously schedules will be changed, and a new article 371F was added. ठीक है. इतना सा याद रख लेना सिक्किम के केस में for prelims. The rest you will do in post independence India in mains. ठीक है. We will do that later. So इतना याद रखो. So now we reached till 22nd state. Then again in 1987, this date you have to remember, 3 new states were created. ठीक है. Mizoram, Arunachal Pradesh and Goa as the 23rd, 24th and 25th state. ठीक है. Remember 23rd, 24th, 25 we reached. ठीक है. उसके बाद 2000, these two तो you might be knowing because these are the recent things. ठीक है. So we were in school or something, तो वैसा कुछ था. 2000. So Chhattisgarh, Uttarakhand and Jharkhand were created as 26, 27 and 28 state of the Indian Union. ठीक है. So till 28 we reached. Then recently we know that Telangana was created in 2014 as the 29th. Okay, so this is the 29th, but why we have 28 states only? Because J&K is now the UT. ठीक है. So otherwise we had earlier the 29th. If now the state is given the statehood again, then we will again be 29 states. ठीक है. So then definitely this act was to be enacted to bifurcate Andhra Pradesh into Andhra Pradesh and Telangana. ठीक है. Then something is written about J&K and Ladakh. I told you already. Now we are the union territory, है ना? After the abrogation of 370. By this, the Constitution Order of 2019, it amended the earlier order of 1954. So now J&K is a union territory with legislature, and Ladakh is a union territory without legislature. And Ladakh will have the Kargil and the Leh district. Okay. State to UT, no need to amendment. No, that we can do. We came up with the this presidential order, na? ठीक है. You can do that. Okay. So now we have the 28 states and 9. Why we have 8 UTs only? Because something was merged, है ना? What was merged? Which 2 UTs were merged? Quickly. This was in current, है ना? So you will do this. There was merger, है ना? Otherwise we had 9 UTs. Now we have 8 only. So questions I'll take at the end. Please just give me the answer. Dadar and Nagar Haveli, Daman Diu Nagar Haveli. ठीक है. You have to do this for current में भी, तो you know this. ठीक है. Just remember 28 states, 8 UTs. That's it. Now the change of the names. So a name can also be changed, है ना? This can also be done under Article 3. So what happened was the United Province was changed into UP in 1950. उसके बाद मद्रास into तमिलनाडु in 1969. ऐसे याद रख लेना, एक कुछ बना लेना. ठीक है. 1969. This can be chronology पूछती है UPSC. UPSC has some गहरा रिश्ता with chronology. ठीक है. So you should be knowing कि पहले क्या हुआ, बाद में क्या हुआ, things like that. उसके बाद 1973 Mysore was renamed as Karnataka. ठीक है. In the same year, this Lakshadweep, Minicoy and Amindivi, they were changed into Lakshadweep. So 1973, 2 things happened. उसके बाद जस्ट रिमेंबर लाइक दिस, है ना, ताकि यू विल रिमेंबर दिस. उसके बाद 1992 में यू नो दैट एनसीटी, ठीक है, 1992 we have this act also that we will do later, the 69th amendment act, है ना. Then in 2006 उत्तरांचल was renamed as उत्तराखंड, पौंडीचेरी as पुदुचेरी, and 2011 में उड़ीसा was changed into ओडिशा. So make a table, है ना, और यहाँ पे एक ऐसे करके यूनाइटेड प्रोविंस was changed into यूपी. बस इतना करके, है ना, यहाँ पे साइड में बना लो. डोंट मेक नोट्स, इतना टाइम नहीं है आप नोट्स बनाओगे, बिकॉज यू कैन नॉट रीराइट एंटायर लक्ष्मीकांत, दैट इज नॉट पॉसिबल. सो जस्ट यहाँ पे इतनी जगह है, इसी पे लिख लो, ठीक है, साइड में अपने whatever way you have writing, ठीक है, इस तरह से बना लेना, so that you can quickly before pre you can go to this page, ठीक है. So this is the chapter 5. Okay, now we'll take the chapter. Doubts we'll take at the end, don't worry, ठीक है. वैसे इसमें डाउट तो है नहीं कुछ, this is all factual, है ना. I cannot do anything, this has been done already by the government, so you have to remember this. Okay, so this is the most driest part, है ना. Everybody wants to leave the citizenship chapter, but we'll just go through quickly, and just remember the part 2, okay, and the articles 5 to 11, very important. Now we know that within India we have two types of people that are residing. One is the citizen, other is the alien. Who are the citizen? Citizen, we are the full members, we are the citizen, I'm the citizen, you are the citizen. We enjoy all the rights, all the civil, political, economic, social, whatever rights we have in India, we enjoy all those, okay. Then who are aliens? These are the citizens of other states, है ना, and they cannot enjoy. Obviously citizen can never be equal to alien, na, है ना. There should be some difference between our own citizen and some citizen of some other country. So they don't enjoy all the civil and political rights. Then among aliens, we have what? We have some friendly aliens, we have some enemy aliens. ठीक है. So friendly aliens are those we enjoy cordial relation with, ठीक है, like we have Russia, हमें उनके साथ गहरी दोस्ती है, तो वो हमारे फ्रेंडली एलियन हो गए, ठीक है. एनिमी एलियंस आर दोज वी आर एट वॉर विद, सपोज पाकिस्तान, है ना, वी आर ऑलवेज एट वॉर विद पाकिस्तान, वेदर द वर्ड वॉर और द literal war, ठीक है. So they will become the enemy alien, ठीक है, simple. Friendly alien and enemy alien. So if you are an enemy alien, you won't enjoy article 22. This we will do today. So first you have to go to the immigration center, then you have to go to the local police, you have to keep them updating that we are here, we are for this purpose, okay, we have all the legal documents and things like that. They have to keep on updating if in case some Pakistanis in India right now, so they have to go through this process, ठीक है, simple. उसके बाद for citizens, what all rights and privileges we have in constitution, this you should be remembering like by heart, ठीक है. So article 15 is there, article 16, कोई भी पूछे कभी भी कि कौन से rights है which are exclusively for citizens, just close your eyes and you should be able to say 14, 15, 16, 19, 29, 30, that's it, ठीक है. इसमें कोई गलती नहीं होनी चाहिए. 15, 16, 19, 29, 30. So जो मेरा पिछला बैच है, I don't think they should have any problem in this. I mean it, okay. Then the right to vote. Obviously, if you are the citizen and you are 18 years of age, then you have the right to vote under Article 325, 326, है ना? That we will see. The right to contest, because we have the political democracy in India, so we can contest. I can contest the election. Nobody can stop me, है ना? You can contest, so everybody can. So we are eligible to hold any public office. We can become the president, the vice president, the judge, if we qualify to. If we are winning the election, if I have some degree, so I can become the judge also, I can become the governor if I satisfy the condition, the attorney general, whatever post is there, है ना. So because I am the citizen of India, ठीक है. उसके बाद just this might be asked in the form of a statement that so who can become the president in India and who can become the president in USA, ठीक है. In India we have both the provisions. If you are a citizen by birth, you can become the president. If you are a citizen by naturalization, this we will do in a while, ठीक है. So both the options are available for you to become the president. But in USA, ठीक है, you can become president only if you are the citizen by birth. ऐसा नहीं है कि naturalization के बाद you are become the citizen and you are eligible to become the president, ठीक है. So last time also I told you people that Kamala Harris, there was when she became the vice president, there were so many questions that how can she become, है ना, because she has Indian roots, this and that. But then she said that I have some roots, my past generations were in India, but I was born in California in America, so I am the citizen of America by birth. Therefore, I am very much eligible for any official post. ठीक है? So, but in India, if you are not a citizen, but you are acquiring the citizenship by naturalization, we will see what naturalization is, then we can become the president. So now this is the constitutional provision, है ना? Now we will go into the articles 5 to 11, part 2. You have to cram this, है ना? There is no other option. So these provisions, the constitutional provisions, they will tell you that who all are the citizens of India, है ना? But when on this date. उसके बाद क्या होगा? That will be dealt by the parliament through an act. ठीक है? Citizenship Act of 1955 that we will see. ठीक है? उससे पहले जो till on 26 Jan 1950 whatever is there is written in these articles. उसके बाद वाला will deal this act will deal उसके बाद वाला. ठीक है? Then it does not deal with any problem or acquisition loss. I told you because that act is given here. ठीक है? उस time पे it was left to the parliament because that was the time when India was born as an independent nation, है ना? So उस time पे, so you people are here residing in India currently on 26 Jan this and this. So these are the provisions. You can enjoy the citizenship. Rest parliament will see with the coming time as per the situation. ठीक है? Accordingly, this act was enacted and this we will see this act. Firstly, let me tell you this these articles. ठीक है? You should बस pre के लिए इतना काफी है. ठीक है? The means of acquiring citizenship 5 means and 3 ways of losing it उतना काफी है. थोड़ा सा देख लेना. उसके बाद these articles आपको पता होनी चाहिए 26 Jan 1950 के टाइम what does article 5 mean. बस और कुछ नहीं पूछेंगे. Trust me. Citizenship chapter you can skip after reading this. ठीक है? बाकी तो आप छोड़ ही सकते हो. So what is Article 5? So those who were the citizens, those who were residing in India at the commencement of the Constitution, Article 5 will deal with that. ठीक है? Article 6 is those who migrated to India. ठीक है? They were in Pakistan but they migrated to India. That is Article 6. So these are the provisions for those people. Then Article 7 is what? Those who migrated from India to Pakistan but वहां पे उनको मजा नहीं आया. They came back to India. They returned. ठीक है? So Article 7 deals with that. Then Article 8 is for Indian origin people, but they are residing outside India. तो उनका क्या? ठीक है? Article 8 will tell you. Then Article 9 is for those who voluntarily accept the citizenship of other country. ठीक है? If you are accepting the citizenship of this, है ना? And we have the single citizenship in India, so obviously you have to renounce the Indian citizenship, है ना? दो तो नहीं रख सकते हो, तो एक ही चलेगी. So Article 9 will deal with that. Then 10 is what? The continuation of the right of citizen. If I am the citizen right now, so I'll continue to be the citizen. ठीक है? Until some things are mentioned there which will be in the Article 10. ठीक है? Then Article 11, Parliament has the power to regulate. So that is why Parliament came up with the Citizenship Amendment Act. So nobody can challenge Parliament. Why? Because Article 11 is there. Article 11 has given the power to the Parliament to come up with anything. ठीक है? To govern, to regulate, to control the citizenship. It can. ठीक है? कोई कुछ नहीं कर सकता है. Now this is sort of detail. इतना याद रखने की जरूरत नहीं है. इतना पेज काफी है. Trust me. इससे बाहर I don't think आया भी नहीं है कभी. I don't think आएगा भी. ठीक है? So Article 5 is for those who were in India. ठीक है? They were either born or either their parents were born in India और वो वहाँ पे थे 5 साल से already. 26 Jan से पहले 5 साल तक they were in India. So they will be the citizens of India. ठीक है? This is Article 5. 6 is simply some dates are there. ठीक है? याद रखने की जरूरत नहीं है. This won't be asked, trust me. ठीक है? So अभी I told you, so if some people migrated from Pakistan to India, so Article 6 is about that. So now you are in India. ठीक है? Earlier you were residing in Pakistan because that was the undivided India at that time. But obviously he will be now in India, so uske parents or grandparents might have been in India because at that time it was the undivided India. So you have to see these at the time of these 3 dates के पे क्या हुआ था. ठीक है? अगर he migrated to India before this 1948 and he was ordinarily residing in India, तो no problem, you can stay there. ठीक है? Before this date आप वहां रह रहे थे तो आप रह सकते हो. लेकिन if you are coming after this date 1948, तो you have to and you have registered, okay, wherever you are supposed to register, in the under the competent authority, ठीक है, तो you will be the citizen of India. But a person could be registered only अगर वो 6 महीने तक यहाँ रह रहा होगा, 6 महीने हो गए, 6 महीने के बाद a person will go to the competent authority with the registration certificate that I want to be registered as a citizen of India, so the person will be registered. इतना याद रखने की जरूरत नहीं है, just remember के 6 क्या है, P to I, ठीक है, 7 क्या है, I to P to I, IPI, ठीक है, इतना याद रखो, इससे ज्यादा रहेगा भी नहीं याद, ठीक है. 8 is what? It is for persons of Indian origin who are residing outside. So ordinarily you are residing somewhere, but you have to keep on constantly informing the diplomatic or the consular representative that currently I'm residing in this country, but obviously वहाँ पे हमारा consular representative होगा, है ना? We have the embassies and diplomatic representatives. So he will go there and he will keep on informing the particular consular representative that I'm still the citizen of India. I have not acquired any other citizenship. So I'm here for this purpose, suppose study or job or whatever. So I'm here since 7 years, 8 years, 10 years, whatever is the period. So I want to continue the citizenship. So obviously the person can, okay, then you can acquire the Indian citizenship also, okay, this under this article. Okay, so just remember कि if somebody is residing outside, so उसके लिए क्या provisions है, that is in article 8. Don't go into detail, याद नहीं रहेगा, ठीक है. फिर 9 is what? If you are acquiring the citizenship of some other country, then obviously you will no longer be Indian citizen. Simple. Then 10 is nothing but the continuation. ठीक है, don't go into detail. 11 is what? Parliament is empowered to make any law regarding the citizenship. Okay. Then there is this act. ठीक है, till now we were dealing with the constitutional provisions. Constitution में इतना ही लिखा है. Now other things are dealt by this act. ठीक है, Citizenship Act of 1955. So this is the acquisition. This is the loss. Acquisition is by these 5 methods. Loss is by 3. ठीक है. So birth, descent, registration, naturalization, incorporation of territory, renunciation, termination and deprivation. ठीक है. So in birth again respond be asked कि detail तो नहीं पूछेंगे, ज्यादा से ज्यादा पूछेंगे we can acquire the citizenship by, फिर वहां पे options होंगे, then you have to choose. इतना detail में अभी तक नहीं पूछा है and I don't think पूछेंगे भी, ठीक है. But if you can remember 1950, 1987, 2004 तो ठीक है. 1950 से लेके 87 तक if you were born in India, बस पैदा ही हो गए, रेस्पेक्ट ऑफ द पेरेंट, चाहे आपके पेरेंट सिटीजनशिप थे नहीं थे, डजंट मैटर, आप ठीक है बाय बर्थ. उसके बाद इस डेट के बाद क्या, इस डेट के बाद नहीं 1987, उसके बाद ईदर पेरेंट, मतलब मॉम डैड में से कोई होना चाहिए, ठीक है. इफ ईदर ऑफ द पेरेंट इज द सिटीजन देन यू कैन बी द सिटीजन. बट after this 2004 date, ठीक है, 3rd December 2004, both should be the citizens or one should be the citizen, provided the other should not be the illegal migrant. Why this thing was there? Because उसके बाद इस time period पे there was a wave of migration into India, बांग्लादेशी आ रहे थे. So obviously those were the illegal migrants because we cannot accept anybody coming into the India as citizen. So this condition was added that 2014 onwards, whosoever is coming to India should not be the illegal migrant. ठीक है. If somebody is here by holding some the legal documents and the permission, so they can come and settle in India, and their children, obviously, if one of the parent is or both are the citizens, so their children will also be the citizen. ठीक है. हाँ Rohit, will see this later. ठीक है. So then those I told you that everywhere we have the embassies, है ना, in every nation. So we have the embassies. Delhi में आपने देखी होंगी. So those embassies, in those embassies there might be some foreign diplomats and enemy aliens. ठीक है. So उनके बच्चे cannot acquire citizenship by birth, है ना. This is the exception. So foreign diplomats are there for their own country, तो हम उनको थोड़ी citizenship देंगे, ठीक है. By descent, again 3 dates, if you can remember तो ठीक है, नहीं तो you can, no problem, ठीक है. 1950, 1992 and 2004. So till 1950 to 1992, if father was citizen, then बच्चा भी citizen, ठीक है. But in 1992 there were LPG reforms and there were so many reforms made. तो उसके बाद since women का भी थोड़ा, ठीक है, feminism wave आ चुकी थी, women men दोनों equal है, तो इधर parent हो गया, ठीक है, father को इधर कर दिया. 2004 के बाद अगेन अगर इफ अ पर्सन, सी उस टाइम पे क्या हो रहा था, ऐसे देखा गया कि लोग क्या कर रहे थे, सिंस एलपीजी रिफॉर्म्स वे थे, लिबरलाइजेशन वाज, ग्लोबलाइजेशन वाज देयर, सपोज कपल है एंड दे वेंट टू यूएसए, या कोई भी कंट्री, मान लो ऑस्ट्रेलिया, व्हाटएवर, ठीक है, कहीं भी गए, सो दे आर गिविंग बर्थ टू दैट चाइल्ड देयर, ठीक है, वहां पे बच्चा पैदा हो गया। सो नाउ दिस बच्चा, इफ यू आर, कुछ कंट्रीज में ऐसा है वहां पे बच्चा पैदा हो गया तो द पर्सन विल बी, द बेबी विल बी द सिटीजन ऑफ दैट कंट्री। सो क्या करते थे लोग उस टाइम पे, वहां पे जाके दे वेर अवेलिंग ऑल द बेनिफिट्स। सो ये बच्चा वहां का सिटीजन है, सो दिस बच्चा विल हैव द हेल्थ बेनिफिट, द फ्री एजुकेशन, इफ उस कंट्री में ऐसा कुछ हुआ, ठीक है। But after some years, the person is returning to India. This couple, along with the baby, is returning to India. So baby has now attained a lot of this education, foreign education from outside, and now he will want to attain the avail the benefits in the India. क्यों? क्योंकि वो Indian citizen भी है। सो फिर क्या किया गया, टू अवॉइड द पासपोर्ट ऑफ द बोथ द कंट्रीज। ऐसा नहीं होगा कि आप दोनों के सिटीजनशिप एंजॉय करोगे, नो। सो इन 2004 क्या बोला गया, आफ्टर 2004 अ पर्सन बोर्न आउटसाइड, इफ यू आर born outside in any country, ठीक है, and if registered as at an Indian consulate, अब वहां पे जाओगे, आप consular representative के पास जाओगे within 1 year, जैसे यहाँ पे we have to, whenever a baby is born we go to the a particular authority, suppose in Kashmir we go to the BDOs, ठीक है, so the BDO will give you the birth certificate, है ना, block development officer. Similarly there in that country you have to go to the consulate, you have to register the birth of the baby so that we know that our citizen is there in that country, so that this duality is is not ensured, ठीक है। So duality should not be there, so just to address that this thing was kept in place, है ना, easy to remember. So just remember कि हाँ descent भी कुछ है जिसकी वजह से हमें citizenship मिल सकती है। उसके बाद registration, इसमें बहुत सारे points है। इफ यू कैन रिमेम्बर, नहीं रहेगा याद, मुझे कभी नहीं रहे तो आपको भी नहीं रहेंगे, नहीं रहते हैं, ठीक है, इट्स ओके। अब क्या, कौन रजिस्टर कर सकता है, गवर्नमेंट बोलेगी, ठीक है, कोई सिटीजन कैन, अ पर्टिकुलर पर्सन कैन रजिस्टर फॉर द सिटीजनशिप, बट प्रोवाइडेड यू आर नॉट द इलीगल माइग्रेंट, ऑब्वियसली तो उनको तो नहीं मिलेगा, ठीक है। एनी ऑफ दी फॉलोइंग कैटेगरीज कंडीशंस हैव टू बी, एनी, ऐसा नहीं कि सारे ABCDEFG तक सारे फुलफिल करने, नहीं, एनी, कोई भी फुलफिल हो जाए तो आपको बाय रजिस्ट्रेशन सिटीजनशिप मिलेगी, ठीक है। अगर आप पर्सन ऑफ इंडियन ओरिजिन है, ठीक है, यहाँ पे लिखा है इंडियन ओरिजिन क्या होता है, अच्छा पहले मैं वही बताती हूँ। तो इंडियन ओरिजिन क्या होता है, एनी पर्सन विल बी कंसिडर्ड एज अ पर्सन ऑफ इंडियन ओरिजिन इफ ही और ईदर ऑफ हिज पेरेंट, या तो वो खुद उस टाइम पे यहाँ था जब अनडिवाइडेड इंडिया था, ठीक है, खुद था या उसके पेरेंट्स थे उस टाइम पे, तो दोनों पर्सन ऑफ इंडियन ओरिजिन विल बी कंसिडर्ड, ठीक है। सो नाउ इफ यू आर अ पर्सन ऑफ इंडियन ओरिजिन, आप खुद यहाँ पे थे उस टाइम पे जब हमें इंडिपेंडेंस मिली, या आपके पेरेंट्स यहाँ पे थे, ठीक है, और आप या तो आप, ठीक है, यू आर दैट पर्सन ऑफ इंडियन ओरिजिन एंड यू आर रिजाइडिंग हियर फॉर 7 years कंटिन्यूअसली, एंड देन आफ्टर रिजाइडिंग फॉर 7 years यू आर गोइंग फॉर द रजिस्ट्रेशन, तो ठीक है, आपको मिल जाएगी। दूसरा, आप पर्सन ऑफ इंडियन ओरिजिन हो, ठीक है, बट हु इज ऑर्डिनरी रेजिडेंट इन एनी कंट्री और प्लेस आउटसाइड अनडिवाइडेड इंडिया, उस टाइम पे आप रह रहे थे किसी और कंट्री में, लेकिन आप उस टाइम पे इंडिया के सिटीजन थे, ठीक है, आप भी रजिस्टर कर सकते हो एज सिटीजन, यू डोंट हैव टू रिमेंबर दिस। देन समबडी इज मैरिंग टू द सिटीजन ऑफ इंडिया, तो उसको भी 7 साल यहाँ पे रह के सिटीजनशिप मिल जाएगी, नो प्रॉब्लम, उनके बच्चों को भी मिल जाएगी, ठीक है। या कोई 18 years हो गया तो जिसके पेरेंट्स रजिस्टर्ड थे एज सिटीजन ऑफ इंडिया, तो ऑब्वियसली उसके बच्चे भी हो जाएंगे एट द एज ऑफ 18, ठीक है। और इफ either of your parents were the citizens of India and for 12 months now you are residing in India, तो आपको भी रजिस्ट्रेशन के बाद मिल जाएगी। या आप OCI कार्ड होल्डर हो, आप 5 साल यहाँ रह रहे हो, ठीक है, और आप रजिस्ट्रेशन से पहले 12 महीने यहाँ रह चुके हो, ठीक है, तो ऐसी ऐसी चीजें हैं, तो इतना नहीं याद रहेगा, सो आई वॉन्ट फोकस स्ट्रेस ऑन दिस, ठीक है। नाउ नेचुरलाइजेशन, इतना बस याद रख लो, जब सिटीजनशिप अमेंडमेंट एक्ट आया था तो यहाँ पे एक प्रोविजन जो है वो चेंज हो गया था, इसीलिए दिस नेचुरलाइजेशन इज अ लिटिल बिट, थोड़ा बहुत पता नहीं चाहिए कि नेचुरलाइजेशन क्या है, ठीक है, ये भी एक वे है ऑफ एक्वायरिंग सिटीजनशिप, यहाँ पे आपको ये सारी कंडीशंस फॉलो करनी है। ओके, सो इफ यू आर नॉट ए सब्जेक्ट और सिटीजन ऑफ एनी अदर कंट्री, ऑब्वियसली तब तो नहीं मिलेगा, बट क्यों नहीं मिलेगा, क्योंकि if that country is not allowing this dual citizenship, तो इंडिया वहां पे नेचुरलाइजेशन के थ्रू नहीं दे सकता है, ठीक है। तो इतना डिटेल में मत याद रखना, बस वो एक प्रोविजन याद रखना जो मैं आपको बोलूंगी जो चेंज हुआ है, बाकी won't be asked. Then if you are renouncing, if he is a citizen of any country and he wants to renounce citizenship of that country, then you can apply here and you can become the citizen by naturalization, ठीक है। if he has either resided in India, या आपने कोई, आप यहाँ रह रहे हो और आप गवर्नमेंट को कोई सर्विस जो है रेंडर कर रहे हो, ठीक है, एंड यू आर रिजाइडिंग हियर फॉर 12 months, तो 12 months के बाद आप अप्लाई कर सकते हो। या फिर दिस पर्टिकुलर प्रोविजन वाज चेंज, तुम बस इतना याद रख लेना अंडर नेशनलाइजेशन, बाकी यू कैन फॉरगेट, ठीक है। सो पास्ट 14 years में, अभी जो है सपोज 2023 है, तो 2023 को -14 करो, तो 14 years जो है विल बी कंसिडर्ड, ठीक है। विद इन 14 years आप यहाँ पे, अर्लियर द प्रोविजन वाज आउट ऑफ 14 years, अगर आप 11 years यहाँ रह रहे थे तो यू कैन गो फॉर नेशनलाइजेशन, ठीक है। दिस वाज नाउ चेंज्ड, आप अब आपको सिर्फ 6 साल, 14 में से सिर्फ 6 साल, इफ यू आर हियर फॉर 6 years, ठीक है, out of the 14 previous years, then you can be given the citizenship by naturalization. This thing was changed from 11 to 6, it was changed, ठीक है। बस बाकी एक चीज याद रख लेना कि यूजुअली नेशनलाइजेशन हम किनको देते हैं, जिनका गुड कैरेक्टर हो, जो गवर्नमेंट को कोई सर्विस रेंडर कर रहे हो, या जिनका इंडिया में रह के कोई फायदा हो रहा हो, ठीक है। वी शुड गेट बेनिफिट, इफ समबडी इज हियर इट शुड बी अ रिसोर्स फॉर अस, देन वी विल बी हैप्पी टू गिव द सिटीजनशिप, है ना। फालतू लोगों को तो देने का कोई फायदा नहीं है। और इफ यू हैव द नॉलेज ऑफ एनी लैंग्वेज मेंशन इन द 8th schedule, आपको तब भी मिलेगा, ठीक है। सो एक कंडीशन यहाँ पे ये भी है कि गवर्नमेंट चाहे तो ये सारी कंडीशंस वेव ऑफ कर सकती है, ठीक है। ऑल दिस कंडीशन कैन बी टोटली वेव्ड ऑफ if you are rendering some distinguished service, or you have some knowledge in science, philosophy, art, literature, world peace, and things like that, then government can give you the citizenship on the basis of these things, ठीक है। And you have to take the oath of allegiance, okay. Rohit will take questions at the end, है ना, अभी नहीं। So let's finish, otherwise खत्म नहीं होगा तो फिर there is no fun, है ना। At the end you can ask me anything, ठीक है, अगर मुझे पता होगी तो I'll answer। उसके बाद है by incorporation of territory, ठीक है, this is the 5th। So सिंपली कोई भी टेरिटरी इनकॉर्पोरेट की, लाइक हमने पौंडीचेरी की, तो हमने सिटीजनशिप ऑर्डर लेके आए, तो उसके सारे सिटीजन्स बिकेम द सिटीजन ऑफ इंडिया, सिंपल, है ना। देयर इज नथिंग इन दिस। नाउ देयर वाज some accord and some things within this accord. Now this is important, why? Because Citizenship Amendment Act was there, है ना। So this accord was there in 1985. So there was this amendment act made in the citizenship of 1955, है ना। This was in the 1985, remember this date is important, ठीक है। It added some provisions within the citizenship, and this came to be known as the Assam. So this was the Assam Accord actually. तो पहले accord हुआ, उसके बाद act आया, so that the original act could be amended. So now you have to remember this date and this date, ये याद रख लेना, can be asked, ठीक है। So all PIOs, the persons of Indian origin who came to Assam before 1st Jan 1966 to till 1st Jan 1966, if you are coming from Bangladesh, ठीक है, to Assam, because the migrants were coming from Bangladesh to Assam, so this particular case was made. So till 1st Jan 1966 you are coming from Bangladesh and you are residing in India, ठीक है, ordinarily, since the some किसी भी डेट को आप आए हो और 1st Jan 1966 आप वहां पे रह रहे हो, तो आपको you will be considered the citizen, ठीक है। This is till 1966, आपको we will give you the citizenship. Then but what after, on or after this date, है ना। So after 1966 but till 1971, ठीक है, before March 25, this was the cutoff date, March 25, 1971, if you are coming from Bangladesh and you are residing in Assam ordinarily, then you will be again considered as a citizen, ठीक है, but you have to register yourself, and till 10 years you will not be given the citizenship rights that we enjoy, ठीक है। So after 10 years you will be given the right to vote. So after the expiry of 10 years from the detection of foreigner, ठीक है, क्योंकि 1971 suppose this is the cutoff date, so suppose somebody on 24th March या कोई भी date, ठीक है, you are declared as a foreigner, you are not a citizen of this India, you have come from Bangladesh, then you have to register yourself. So you are the foreigner right now, so you will register yourself. So after 10 years you will be given the right to vote and all other rights that the citizens enjoy. And this was a Assam Accord, and this was an amendment made in 1985, ठीक है। Now at the end of the chapter we will see why this CAA was opposed by the Assamese. Why this was opposed? Because this cutoff date was changed to 2014, है ना? This we will see at the end. ठीक है, अभी तक just remember 1966 and 1971. Okay. Now come to the loss of citizenship. There are 3 ways of doing this: by renunciation, by termination, by deprivation. Okay, and this is again mentioned in the act and not in the constitution. So kabhi aayega statement could be the constitution prescribes 3 ways of citizenship. Suppose renunciation, loss of citizenship, renunciation, termination, and deprivation. So you will not focus on the word constitution. Aap dekhoge renunciation, termination, deprivation, you will mark that correct. But you should be very well aware that this is not in the constitution, this is in the act. ठीक है, constitution में only 5 to 11 articles are there. ठीक है, now what is now the renunciation? Now, if somebody is the citizen of India of full age means 18 ho gaya hai, above 18, and capacity, so you can declare that I don't want to be the Indian citizen, I want to attain the citizenship of America, so I want to renounce my Indian citizenship. So you have to register this declaration. So you will declare this. Okay, then it's up to the government. If government accepts that, then fine. If government is not accepting, for example, if it is the time of war, suppose we are waging a war against USA, okay, and the person wants the USA citizenship, at that time we can hold it, है ना? Because the citizen of India will have some of the information in India which he might pass to the USA, है ना? We don't want that. So उस time पे हम ऐसा नहीं करेंगे, ठीक है? But if it is the normal condition, government obviously will accept it and say that go and enjoy, है ना? So obviously when the person renounces the citizenship, तो minor child or या उसका spouse also they will lose the citizenship, ठीक है? But at the age of 18 he can resume the Indian citizenship. तो उसके लिए we have the 5 ways, है ना? That we already read. Then termination के time पे, if you voluntarily are acquiring the citizenship of any other country, then obviously you will cease to be the citizen of India. And here you don't need to declare, you don't need to register the declaration. Automatically you will lose the citizenship of India. ठीक है. However, also at the time of war we have to take care of the security situation. तो वहाँ पे थोड़ा government will see. ठीक है. Then deprivation. So deprivation के time पे who will be deprived of citizenship? If somebody has attained citizenship by fraud, झूठ बोला, ठीक है, registration के time, so उस time पे fraud by means of fraud, तो obviously later on that will be detected and he will be deprived. Yeah, somebody has shown disloyalty to constitution, since the constitution is supreme, है ना? So we cannot bear this, we cannot entertain this disloyalty, so the person will be deprived. Then somebody has traded or communicated unlawfully something to the enemy nation again, है ना? Yeah, so you had attained the citizenship by registration or naturalization या जो भी, ठीक है? तो within the 5 years आप citizenship acquire करने के 5 साल के बाद हमें पता चल रही है कि 5 साल में तो 2 साल आप जो है you were imprisoned in any country. In any country you are imprisoned. मतलब आपने कुछ criminal act किया है, you were imprisoned out of the 5 years. For 2 years you were imprisoned. अगर 2 years से कम था तो it's okay. 2 years हो गए आप imprisonment में, तो you will lose the citizenship. ठीक है? या you are residing outside India for 7 years and you are not communicating something to the you are not communicating to the consular representative, then again you will lose the citizenship. ठीक है? इतना detail में नहीं पूछते हैं, just remember the 3. Then single citizenship, we know that in India we don't allow the dual citizenship, like in case of the America or Switzerland. ठीक है? They have the dual citizenship, we don't have. We have the single citizenship. And this has a particular benefit also. What is the benefit? That in the nation, in the country where we have the single citizenship, every citizen is equal. ऐसा नहीं है कि Kashmiri is superior than suppose any other state, है ना? Rajasthan, Bihar, Gujarat, whatever, or Gujarati is superior over MP, है ना? Because we don't have the state citizenship. ऐसा नहीं है कि कोई prosperous state है, suppose Kerala हो गई, prosperous है, तो their citizenship, they will have since because of the dual citizenship, they will have some extra benefits, है ना? ऐसा नहीं है. So that every citizen enjoys the same rights, privileges, whatever advantages we have in India. So that is the benefit, अगर कोई पूछेगा what is the benefit of single citizenship, why do we have single citizenship, ठीक है? So this is the benefit that everybody is equal, we have the same political, economic, civic, whatever rights we have, there is no discrimination, all are equal, ठीक है? Now, but there are some exceptions. These exceptions we will do in detail in fundamental rights. So under Article 16, we can prescribe the residence as this criteria for some jobs, है ना? Particularly the non-gazetted jobs in these states. ठीक है? Abhi currently it's only in Andhra Pradesh and Telangana. Then again under 15, we can give some of the affirmative action we can make. We can offer some concessions in fee. है ना? This we will do in next chapter, don't worry. Then Article 19 to protect the tribal culture, their this language, script, etc. So the movement is restricted in those areas. So यहाँ पे we see थोड़ा बहुत you know मतलब थोड़ा बहुत advantage है ना of some of the citizens over the other citizens. These are some of the exceptions. But what the general rule is, all are equal. Nobody is superior, nobody is inferior. ठीक है? So we know that in Kashmir till 2019 we had the permanent residentship was here, and nobody could come from outside and enjoy the employment or any property or any scholarship in the Jammu and Kashmir. But now this is gone. This was under the order 1954. Now we have the order 2019, and everything was scrapped. Okay. Now we have the single citizenship without any this exception like J&K. Okay. And this we had taken from Canada, so as to, if this is the other reason, one was that equality thing, second is the to promote the feeling of fraternity and unity among all. Okay, we won't say we are I'm Gujarati, I'm Marathi, I'm Keralite, I'm this and that, I'm Northeastern, है ना? What we say is that we are all Indian. Okay. So now there is this topic was in news also, the overseas OCI card holders. ठीक है. So I'll tell you in brief ये क्या है. Okay. So there was a need in 2000s. ठीक है. That since the importance of diaspora was growing, ठीक है, by leaps and bounds, therefore the committee was set up under the chairmanship of LM Singhvi. So they wanted that we should tap the potential of the diaspora. Let's tap their potential. Let's make them do something constructive for their own nation. Okay. So then the committee submitted its report after 2 years in 2002. So and it recommended the amendment of this act to provide for the dual citizenship to PIOs. Now, अब हम directly तो dual citizenship we cannot give, है ना? Because we have the single citizenship. So we gave them the sort of citizenship, but indirectly, थोड़ा sub citizenship sort of, है ना? Directly हमने citizenship नहीं दी, ठीक है? So this was the backdoor sort of thing. Okay, so that the diaspora feel more connected to India, and they can, you have to remember this line, they can have the constructive relationship with India. Okay, this was the mandate. So what happened was, accordingly, this act was passed in 2003, and it made provision for the acquisition of OCI by the PIOs. So till now we have the people of India, a person of Indian origin. Now you can become the overseas citizen of India, overseas but citizen of India. So you are citizen, but you are residing somewhere, है ना, overseas में. So you can attain this. ठीक है, but if you are residing in 16 specific countries other than Pakistan and Bangladesh, these are excluded, है ना? Otherwise, the 16 countries were included. Okay, but then it was later extended in 2005, and all countries were included within this. So if you are in any country except Pakistan and Bangladesh, you can enjoy the OCI. Okay, you have to go for the registration and other things, so you will become the OCI. Dolly, I'll take the questions at the end. Okay. NRI something different. I'll tell you at the end. Just remind me. Okay. So now, so where was I? So there was this extension. Okay. See, ऐसे थोड़ा flow बिगड़ जाता है. Okay. So at the end, just ask me. Till then, just please keep your doubts with you. Then I'll address at the end, because we have the time limit. So in 2005 this was extended from 16 countries to all. Okay, and the only exception was the Pakistan and the Bangladesh. But you have to remember the OCI, they are not actually the dual. This is not the actual dual citizenship, है ना? Because we follow the single citizenship only. So this is, I told you, the backdoor sort of thing, है ना? So in 2015, again this was amended, Citizenship Act was amended, and this new thing was brought in, the OCI card holder thing. Why? Because there was some confusion. So PIO lena hai, OCI lena hai. So diaspora, so it's instead of facilitating the relationship between India and diaspora, it was creating confusion because people didn't know. अब वो इतना detail में तो जाएंगे नहीं, PIO लेना है, OCI लेना है, क्या लेना है. ठीक है. If there is any person in the class who cannot understand Hindi, please raise your hand, because sometimes I use Hindi also. If it is okay, then I'll continue. If not, then I'll stick to English only. So if anybody is not able to understand, please let me know. Okay? You can comment in the chat box. So if not, then I'll consider that everybody can understand. Anyway, so there was this confusion between PIO and OCI. Okay? To clear this confusion, it was recommended that, okay, so Ragadi Pika. Okay, I'll not use Hindi. Okay. ठीक है. तो in PIO, so in 2002 there was this PIO scheme. ठीक है. Then later on in 2005 there was this OCI scheme. They were running in parallel. There was confusion. So government decided to come up with something which will be easier for the diaspora to opt for. ठीक है. Then the government went for the merger of OCI and PIO. Now we don't have this distinction. However, the table is given in the Lakshmikant. You can check that. ठीक है, for your own knowledge. So otherwise, I don't think the question will be asked. ठीक है. So we went for the merger, and now we have this. In 2015, we have this OCI card holder. Okay, this is the term that we have right now. So this was replaced. It replaced the nomenclature this and this to OCI card holder, and there were some provisions made in the Principal Act. Now, who can register as a OCI card holder? Who can register? There are some provisions. Okay. Detail you don't need to remember. No problem. Okay, just know that there is something OCI card holder and they can have some benefits in India. And to have the connect with the diaspora, we came up with some provision like this. Okay, so the central government, they can grant the OCI card holder to any person who applies for it if these conditions are met. Firstly, the person has attained the full age and capacity. Obviously, he should be this adult and should have the capacity in the sense that wo kuch incapacity ya mental problem or infirmity that should not be there. Okay? So whosoever is the citizen of another country but was a citizen of India at the time of commencement of the constitution. So at that time, he was a citizen of India. Now, right now, he is a citizen of some other country because he might have shifted. But at the time of commencement, that is 26 Jan. Okay? At that time, the person was the citizen of India. So the person is eligible for OCI card holder scheme. Okay? Second, who is a citizen of another country but was eligible at that time. Okay? Even if the person at that time or during at the time of the commencement of the constitution, he was eligible for citizenship. He didn't take this Indian citizenship, but he was eligible. Okay? He can also be considered for this scheme. Then citizen of another country but belonged to a territory which became the part of India after this 47, like Sikkim or any other part that we have incorporated so many territories from French and Portuguese. So if they belong to that, okay, at that time 1947, so they can also apply for the scheme, okay, or their children, minor, this and that, or their spouse, okay. So if they are together for 2 years, they can go for the OCI card holder scheme. Okay, just have the faint idea like who all can. So uske baad, what are the rights of these OCI? Okay, so there are some rights, and the central government may specify that what are the rights that the government will specify, but they will not be entitled to what? To this public employment. They will not be entitled to the, so this is the difference between now the citizen and the OCI card holder. Okay. So the person, whosoever is OCI card holder, will not be eligible to the public employment. We cannot say that give me Article 16, है so that will not be there. Secondly, he won't be eligible for president, vice president, judge of Supreme Court or High Court, or he cannot be registered as a voter. Okay, remember this. And uske baad, he cannot become, obviously when he is not the voter, he cannot become the member of the parliament or the state legislature. Then he shall not be appointed for the public services or in any post which deals with the affairs of the union or the state, except for appointment in such services and posts that central government may come up with some notification that this particular category of citizens can, sorry, not citizens, this particular section of people can be employed within this particular service or post. So that can be done, but otherwise they cannot. So this is the difference. This you should be knowing. They have some rights also that have not been written here, so we don't need to go into that. But they can renounce also the card scheme. They can totally, if they are declaring that we don't need OCI card holder scheme, then they can. Okay, then they will register and the government will say, okay, you can leave. Then if you cease to be the overseas citizen of India card holder, then your spouse will also cease and your minor child will also cease. Okay, this is the general thing. Uske baad it can be cancelled also if you have attained by fraud, false representation, same things that we saw in the citizenship part. Okay, if by fraud, false representation, concealment of fact, or you are providing some information to the enemy nation. Okay, so in that case you will be, and the same thing, out of 5 years you were imprisoned for 2 years in any country, then again it will be taken away. Then if the and these conditions are to be satisfied: sovereignty, integrity, security of India, and things like that. Okay, or the marriage is dissolved. So you were the OCI card holder and your spouse also got the OCI card holder, but now you got divorced. Your spouse, obviously you cease to hold the card, your spouse will also cease to hold the card. Okay, itna kuch hai nahi, just you don't need to go into the detail. Just you should have some idea what OCI cardholder is, and then the merger of PIO and OCI. If you want to go for the detail, you can just check the table that is in the Lakshmikant. If you want, you can go. Now NRI is a separate category. This is just the non-resident Indian. Okay, you are the NRI is the Indian citizen. Okay, NRI has been only this category has only been made for economic purpose, for the taxation purpose, because they have a different taxation scheme than the citizens. Okay, so NRI is very much the Indian citizen. Okay, NRI is different from PIO and OCI. You can read the chart. Okay, you are the Indian, you are residing somewhere outside, you are not residing in India. Okay, so you can read all the description here. But what you need to remember is that they are the Indian, they are residing somewhere else, but they are constantly updating India that we are the Indian citizen. I am residing here because of this purpose, so I continue to be the citizen of India. Okay, and they will be also liable to pay the taxes, but it will be different from the other citizens who are residing in India, because they are not availing the services and benefits of the Indian, suppose road, Indian, whatever free services we have, the scheme, PDS, etc., but the person is not availing those benefits, so his taxation slab, etc., will be different. But this is the difference between citizen and NRI. Rest you can check the table. Okay, now this was in the news. The last, let me connect the charger 1 second. Okay. So why this CA and RC thing was there? Okay, faint idea I'll give you. You might have covered this in current. Okay, so there were so many migrants coming. Okay, from the 12th century, Parsis, migrants came from Iran, Pakistan, Bangladesh. Then Tibetans came, then Afghani came. You can take the dates. This is important for mains. Okay, abhi ke liye you don't need to remember this. Then till Rohingyas, everybody knows about Rohingyas. So people were coming into India and things were changing. Okay, in 2001 census, we found that there were so many migrants that had come from the Bangladesh and Pakistan. So obviously we have to do something about the illegal migrants. Okay, now who was the illegal migrant? So this definition changed. Earlier this particular category was the illegal migrant, but now after the CAA, Citizenship Amendment Act, this particular the thing has changed. Let's see what has changed. Okay, so earlier everybody was illegal, considered to be illegal immigrant if the person was without the travel documents, without all the legal documents, like Bajrangi Bhaijaan, everybody might have seen, hai na? So Salman Khan came to the went to the Pakistan without the passport and the other document, so he was considered as the illegal immigrant. That is why he was detained. Okay. Secondly, if you have come along with all the documents and all the requirements that you had, okay, you have that, but you have crossed the time period. Suppose you were given the permission of 6 months, but you are here for 9 months. So after 6 months, from 7, 8, 9, so you will be now considered as the illegal immigrant. Okay, so there was no exception, nothing. So this was the definition of illegal immigrant. But now, after this act, if you have entered before this date, 2014, 31st December 2014, if you have entered before this date and you are from Pakistan, Afghanistan and Bangladesh, and you are from these 6 communities, okay, then you will not be considered as illegal immigrant, even if you don't have travel document, even if you have resided here for whatever time period, no problem. You will not be considered as the illegal immigrant. Okay. So then what were the changes made? These were the changes made. I told you, Hannah. So the 11 years was changed into 6 years. Why? Because this was for before 2014. If you have come now, what if somebody comes after 2014? So what in that case? So now if you have come after 2014 and you have stayed here for 6 years, then you will be given the citizenship by naturalization. Okay, so that is the thing. Fine. Then OCI, your OCI cardholder scheme will be cancelled if you are violating any law. This was just to some people were seen creating some fuss within the territory of India. That is why this provision was added. Then there was huge resentment among the OCI people that why you have kept brought this particular provision within the act. Okay. So these were the changes made. Now the illegal immigrant definition is changed. Now if you are from these communities and these nations and come before this, then you are not illegal immigrant. And out of last 14 years, if you have stayed here for 6 years, then you can get the citizenship. And if you are the OCI card holder and you are violating any law, so you will be cancelled. Citizenship will be cancelled. But there were some issues. This is important for mains, not for prelims. Okay. There was why Assamese were not happy with this, because I told you the cutoff date was 1971, 25th March, but now it changed it to 2014. Hence, this thing was there. There was this this conflict at that time. Then there is something called as NPR also, National Population Register. Okay, so this again you might have read this in news, NPR versus NRC. So what is NPR? This is simply the National Population Register. So it started in 2010 that if you are a person and you are residing in India, okay, you can be anybody, any foreigner whatsoever, immigrant, whatever you are. So you have to maintain this list. So if you are residing in India from past 6 months, so your name will be written in this list. Or you have come just 2 days, suppose ago, but you are intending to stay here for 6 months. Again, your name will be included in the list. Okay, it was to be updated after 10 years. That is in 2020, but then there was this, since NRC thing was there, then there was this hue and cry about this NPR also. Otherwise, this was a normal updation that we were supposed to do. Okay, this you will do in the current, don't worry. So this ends the citizenship chapter. Okay. Now we have the fundamental rights. So this is very important. In fundamental rights, every year UPSC will ask either the Article 19 or Article 21. Okay, Baki, if you know, that's good. If you, okay, thoda confusion hai, it's okay. But 19 and 21, you should be very clear. Okay, because, and it will be very generic, like right to privacy comes under which article. Okay, anybody can answer that. So fundamental rights is very easy. Okay. You can remember this easily, no problem in this. So just remember, this is the part 3. Okay, till now we were dealing with the part 2. This is the part 3 and these are the articles. At least the part and the article should be very clear. No mistake can be entertained. Okay. So what was the background? I told you earlier also. So in 2015, there was this Magna Carta. Okay. So what was this Magna Carta? There was actually the King John's, and the King John was taking huge taxes from the landowners. Then the owners, they protested against the king for the, like suppose you are asking for 90% of the taxes, है ना? So obviously this is very huge, so people will revolt. So there was this skirmish between the two, and then King John's came up with the Magna Carta. Okay, I'll give you all these rights, and you will not be exploited, and you will not be, discriminated and other things. Then after this, there was this French Declaration. Okay, this is just the evolution how the fundamental rights came into existence. Then the French Revolution was there. Then American Bill of Rights was there. Okay. Then finally there was this Universal Human Rights Charter 1948. Now I don't know 2020 or 21. There was a question on this. Hai na? We will do this tomorrow. So Universal Human Rights Charter 1948 was enacted. Okay. So all these things were already in place. So this gave a sort of cue to the constitution framers that we should also have something in the constitution. Although there was some demand earlier also like this, but all these things gave the structure or the skeleton to the what we have right now in the constitution. Okay. So these were the reasons why do we have this. Okay. So what the history was, initially the Lokmanya Tilak, you might have read this in history, in the Swaraj bill, demanded some basic rights. Okay. This was the inception. Then in 1922, Annie Besant and Gandhiji, yesterday also I told you Gandhiji in 1922 wanted something in the form of the Constituent Assembly. So apart from that, he also demanded some sort of basic rights. Okay. Then in 1928, there was this Nehru report. Again, there's some 19 fundamental rights were demanded. Then in Karachi session, okay, then there was resolution on fundamental rights that was passed. In 1942, there was Sapru committees. They also demanded fundamental rights, but it was never given, never, until we attained the independence in 1947, and we came up with the constitution, है ना? After so many series of deliberations and debates, then part 3 was enacted, and we got our fundamental rights, what we have right now. So yesterday I told you there was a committee on the fundamental rights that was headed by the Sardar Patel. So that also drafted some of the internal scheme of the fundamental rights. And it is said that usually it is taken from the American Bill of Rights plus the Universal Declaration of Human Rights. Okay, so major portion has been taken from these. So what is the objective? Objective is to establish the government of law. So this can be asked in the form of a statement. Then why do we have fundamental rights in constitution? So that we don't have the rule of man, we have the government of law. Okay, this objective should be clear to you. Now, why are these called as the fundamental? This again can be asked. Anybody can ask you either in pre or mains. So why are these fundamental? Because these are important for the attainment of this intellectual, moral, and spiritual status or your overall development. And these are incorporated into the fundamental law of land, that is a constitution. That is why these are called as fundamental. So these are the two reasons given. Okay. Uske baad, now this we have discussed. We have the legal rights. Okay, this is the broader framework. Within the legal rights, we have the constitutional rights and we have the extra constitutional rights. So within the constitutional rights, then it is divided into fundamental and other non-fundamental. Okay, and in extra constitutional means simply the statutory extra constitutional, which are outside the constitution, which we have enacted some law and made it a right. Okay, for example, right to strike. This is not a fundamental right, but this is a statutory right. Similarly, consumer rights, RTI. These are not your fundamental rights. Although some this RTI can be seen in Article 19 also, you know. But if you are talking about the RTI Act that we enacted separately, है ना? Otherwise, if you are asked, you can write Article 19 talks about the freedom and all these things. We will see. Okay, so this was actually the statutory right also. Then free legal aid, etc., to adoption, etc. So these are the statutory rights outside the constitution. So what is within the constitution is the fundamental right and the non-fundamental. So these are outside fundamental. Okay, this we will do at the end of the chapter 265, 308, 301. So by now you must be knowing this. I am assuming that you have already read polity. Hai na? So I'm here to just brush already what you know. So what is the difference between the fundamental and other rights? है ना? Why these are called as fundamental and why these are called as the other rights, not the fundamental one? Because there's only one difference. What is the difference? Under Article 32. For fundamental rights, you can directly go to the Supreme Court. If your fundamental right is violated, you can go to the Supreme Court directly. But in case of other rights, if your other rights are violated, other rights outside the fundamental rights, you can go to the High Court also under Article 226. Okay, you have to first go to the High Court, and then by way of appeal, you can go to the Supreme. You cannot directly go to the Supreme Court. Okay, this is only for the fundamental rights. You can directly go to the Supreme Court. So this is the basic difference that is there. Okay, the broad difference. Now is the fundamental right. I told you already, part 3, 12 to 35. This should be clear. We took it from Bill of Rights. Okay. Then this is also called as Magna Carta of India. These are justiciable. Why are these justiciable? Because you can go to the court if these are violated. Mahesh, at the end. Okay? At the end. So Magna Carta of India, uske baad these are justiciable, and these are more elaborate than any other constitution, है ना? Because we have the lengthiest constitution. Uske baad these are guaranteed by the constitution, and these are there because we have to uphold the equality and dignity of individual, है ना? And in the larger interest of the nation. Then again, I told you yesterday also, this talks about the political democracy. Okay, and the Jkpsc talk about the social and economic democracy. This we did yesterday, है ना? So just remember political democracy with the fundamental rights. Okay, you should not forget this. This can be asked. Then, so this is the reason why fundamental rights are there. Firstly, this is just to prevent the executive to, exercise the unbridled powers or to usurp all the powers within the executive. These are some of the limitations. That is why we call that. That is why we say that we have the constitutional form of government, है ना? Because the constitution has given some rights to the individuals that the state should not take away. Okay, just to provide the liberty and freedom and the overall development of the citizen. These rights are there, and to provide the limitation on the tyranny of executive and arbitrary laws of the legislature. These things are there. Okay, so, and this is the government of law and not of men. This we already discussed. And these two reasons I also told you why fundamental rights are named so, because these are important for overall development and these are included in the fundamental law of the land. Simple. Then currently we have the 6, earlier we had the 7, but the 31 was taken away by 44 Amendment Act. Now this is the right to property is now the legal right, not the fundamental right. This again we will do. This is just a legal right. And these are the fundamental rights. So we have 6 fundamental rights in total. Why? The right to property was deleted by 44th. This is now a legal right under Article 300A. So in part this, we have only 6 fundamental rights. This we know. Now this features, this is important because a question can be asked on this. So whether fundamental rights are only for citizens or some foreigners also enjoy, you should be knowing. Okay? So some, not all. Some of them are, if word some is there in the question paper, it will be correct. So some are available only by the citizens. You should be knowing 15, 16, 19, 29, 30. Just now I told you these you cannot forget. You cannot afford to forget. Okay? So some are available only to citizens, while some are available to all persons, whether citizen, foreigner, legal person, corporation, company, whatever, that we will see. Then these are not absolute but qualified. Why these are not absolute? Because we have some reasonable restrictions. Again, we will see in every article what are the reasonable restrictions. And the court has said that there should be a balance between the individual liberty and the social control. Okay? There should be a control also, but the individual should have some liberty also. There should be a balance. Okay? Then, so all of them are available against the arbitrary action. So the word all, you should be very particular about these things in prelims, because these things are changed. All will be changed into something every, these words will be there. So you should be knowing where all is, where some is. Okay. So all of them are available against the arbitrary action of the state. Yes, correct. However, some of them are also available against the some, not all. All are available against the arbitrary action of state, but some are available against the arbitrary action of individual. Like 17 is there or 24 is there. You should be very clear. Okay? Some are negative, some are positive, है ना? Some are placing some limitations on state, but some are giving some privileges to people. ठीक है? These are justiciable, so you can go to the courts. Okay, and these are defended and guaranteed by the Supreme Court. Fine, so you can go directly because this is the fundamental right. You can directly go to the Supreme Court, not by way of appeal from High Court. Okay, these are not sacrosanct. Also, these are not permanent. Why? Because you can go for the Amendment Act. You can bring some changes also. But the only caveat you have is the basic structure. This you cannot violate after the case in the Bharti case, है ना? That you already know. This cannot be violated. Other things you can change. These are not sacrosanct. Okay. But then there is emergency also. So these can be suspended except the Article 20 and 21. Fine. And Article 19 also will be suspended only if there is war and external aggression, not in case of the internal emergency. Okay. So these should be very clear. Question can be asked. Okay. There are chances. This we will do later. Okay. I've written later here because this we have to do in detail. And so Article 33 is there. Also, we'll do this in detail. That there are some of the members like the armed forces, paramilitary forces, police forces, etc. And we have the parliament has provided some of the restrictions on them. They cannot enjoy all the fundamental rights that we are enjoying for the security reason. They cannot come online and say whatever information they want. They cannot enjoy right to speak, right to speech and expression, because we have to take care of the security of nation also. Then there is Article 34. That we can go for the application of martial law, and under the martial law your fundamental rights will be curtailed and you cannot approach to the court. That is obvious because martial law is there. It means the military rule. This is Article 34. Then 35 is what? So most of them are directly enforceable. You don't need to come up with a law. Okay, suppose right to equality is there, so we are equal. We don't need to come up with a separate law to give force to the Article 14. But for some other, we need to come up with some this Article 17 was there. It was not clear what untouchability, what is there, because it was not mentioned. So we came up with the Untouchability Offences Act 1955, and we came up with the Prevention of Atrocities Act, SCST, 1989, and we came up with these acts to give effect to this article. So some articles are directly enforceable, some we need to make some laws under Article 35. Simple. Now is the Article 12. Important. You should be knowing what comes within the definition of state. So the state will include this. So whenever state word is there, these 4 points should come to your mind. State means the government and the parliament. Parliament, that is the executive and legislative. Judiciary is not written here, so you should be careful. Judiciary is not written. Only the legislative and executive is written, both at union and at state, same. Then the local authorities, municipalities, panchayats, district boards, etc. This is written. Then any other statutory or non-statutory authority like LIC, ONGC, these things are there. So they will be also considered as the state because the state is directly governing them. Okay. So this has been taken. This is the widest definition given to the state. It's not only the government. No, all these other these 4 points should be clear to you. Then Supreme Court said that if there is any other private agency that is not under the government, but for some period of time the private agency is acting as an instrument of state. Okay. For example, you have when government has outsourced some particular project to you, and this project is important for nation. So for that time period, you will be again considered as the within the definition of the state under Article 12. Okay, this was given by the Supreme Court. So nothing much in this. Then there is Article 13. This is important. So if you are coming up with a law which is inconsistent with the fundamental rights, or is in derogation with the fundamental right, or is in consonance with the fundamental right, that should be unconstitutional and void. Okay, under Article 13. Why? Because you have the doctrine of judicial review. Okay, and this has been given to the Supreme Court and High Court under Article 32 and 226. Fine. Now let's see what law means. Okay, now you are saying that any law cannot be brought in if it is in contravention to the fundamental rights. Now, what is the meaning of that law? So it can be any permanent law enacted by the parliament or the state. Okay, then it can be any temporary law also, like the ordinance by the president or the governor, or it can be any bylaw, rule, regulation, whatever ठीक है, it can be that also. It can be something of custom usage also, that has been there in force since like generations and generations. There is some custom, there is some convention, ठीक है, and we are following that. That will be also considered as law, and that cannot be against the constitution. You should be knowing what law is, ठीक है. Then this thing you have to remember. Then Article 13 declares that the constitutional amendment is not law. It's not law and hence cannot be challenged. So Article 13 is not taking constitutional amendment as the within the definition of law. So only these four things are considered to be the law, not the constitutional amendment. So does that mean you can come up with the constitutional amendment and take away the fundamental rights? Hai na? There can be this question. Then the Krishna Bharati case has propounded that you can go for the for any amendment of the constitution, but the only thing is there is the basic structure. Apart from basic structure, you can make changes, but you cannot change this. Okay, so this is the only thing you have to remember. Rest, this is the Article 13, this is the law, this is not the law, and this can be brought in, but the only caveat is the basic structure. Okay, then this is for mains, but quickly I'll tell you. In Shankri Prasad case, it was held that the parliament can come up with the Constitution Amendment Act, and because the parliament has both the ordinary legislative powers, that the parliament keeps on coming up with laws and acts, etc., and the constituent legislative powers. Constituent means the powers that was enjoyed by the constituent assembly. So it can do any changes, any major changes can be also made within the constitution. So this was held by the Shankri Prasad. Then it was the same thing was maintained from Shankri Prasad to Sajjan Singh case, okay, till 1965 it was maintained, but Golaknath case said that parliament does not enjoy the constituent power, it only enjoys the ordinary legislative powers. So you cannot amend the constitution, you cannot come up with anything and change the features of the constitution. Okay. Why Golaknath Singh case said this? Because the Article 368, which deals with the constitution amendment, it talks only about the procedure and not the power to change it. So therefore parliament cannot amend constitution including the fundamental rights. Then parliament in answer to the Golaknath case came up with the 24 Amendment Act of 1971. So in 24 Constitutional Amendment Act, the definition of this article was changed. Earlier it was only the procedure to amend the constitution. Now it was changed to the power of parliament and the procedure thereof. Now you don't have only the procedure within the Article 365, but the power is also there. Now the parliament changed the entire title of the Article 368. Therefore now parliament has the power to change the to amend the constitution also including the fundamental rights. Okay, this was at that time this was held. Then there was this Krishna Bharati case, very important case. It upheld, it said that okay, let 24 Amendment Act, let's say that this is constitutionally valid because parliament has the power to enact the law. Okay, it can, but again the only thing is that you cannot change the basic structure. This is the gist that you have to remember, that apart from basic structure you can go for the amendment of the constitution. Only this one line is important, and you should know which case has said what, and for mains perspective this is sufficient that only the basic structure is the limitation with the parliament, rest they can do whatever they want. So this is again the same thing, whatever is for citizens. I told you 15, 16, 19, 29, 30. There is some error in this new edition. Otherwise, this is 29, not 21. Okay. So rest are for the foreigners also. You can go through this. Since we are dealing this in detail, so don't worry. Now this is the Article 14. What is Article 14? So there are two connotations in this. One is of British nature, another is of American nature. This. So what is the British connotation of Article 14? Equality before law. That means what is equality before law? The absence of any special privileges. So you are everybody is same. Okay, nobody will be given some special privileges. We are all equal. Any rich is not superior over any poor. Okay, so equal subjugation of all persons to the ordinary law. So everybody, it's not that rich people will be dealt with the different law and poor people will be dealt with the different law, है ना? अभी the recent example, like on a lighter note, in Big Boss, है ना? You saw that MC Stan, he won the Big Boss, है ना? He came from a very poor background. He was a slum dweller. So there was no difference between poor and rich. Everybody could participate in the. So this is how the equality before law is, है ना? So this you can relate to the Article 14. Then nobody is above law, even if it is prime minister, president, or whosoever. We are all equal before the eyes of law. This is the British connotation. Now this is the negative connotation. Okay, this is the negative. Why negative? Whenever you see no, this no is there, this absence is there, it means negative concept. If there is like this, the second concept, which is from American concept, this is the equality before law, all are equal. So this no and absent word is not there. So this means the positive concept. Okay. So equality of treatment under equal circumstances. Why equal circumstances? Because this is a particular this is a very good example, this income tax. Okay, so this suppose everybody is so we have different slabs. So this section of population is coming in this slab, this section of population is coming in this slab. Suppose this is a 5% tax, this is a 10% tax. Okay, so these are equal, that is why these are subjected to this 5%. These are equal, that is why these are subjected to this 10%. It's not that these are equal. No, they are not equal, hence they won't be subjected to the same taxation. Okay, so this is called as equality of treatment under equal circumstances. It's not that unequals are treated equally. No, only the equals are treated equally. Okay, so the likes should be treated alike without any discrimination. So therefore this is the positive concept. Then the Supreme Court has said that where equals and unequals are treated differently, Article 14 does not apply. Obviously, you have to treat equals equally and unequals equally. You cannot treat equals and unequals equally. I hope it's clear. Okay. Okay. Now it has some resemblance. The British concept has some resemblance with the rule of law. This question was asked, I think, I don't know, 2020 or 21. Okay. So what is rule of law? We should be knowing. Okay, it has 3 elements. One, same, the absence of arbitrary power. Okay, that we already dealt, that nobody is above law. We are all equal and nobody can breach the law. If anybody is breaching the law, so he will be punished. Second, equality before the law. So we will be treated all equally. है ना? All will be to the same court. Sorry. There was some voice anyway. So this lex rex, it means that earlier it was the king was supreme, okay, but now the law is supreme. Lex rex means law is supreme. This we will do in the mains, don't worry. So here you don't need to go into this. So we are all equal. Nobody is superior, nobody is inferior. All will be subjected to the same ordinary law of the nation. And the third point that where we differ from the rule of law of the Jkpsc is that Jkpsc says that the constitution is a result of the rights of the individual, but we say that the rights are because of the constitution. It's not that the constitution is because of the rights. Okay, this is the difference, because constitution is supreme in India. Whatever is written in constitution, we have to follow that, and rights are mentioned in constitution. That is why we enjoy rights. Okay, but Jkpsc says that because we are humans, we have some rights. Based on those rights, we have the constitution. Okay, this is the difference. So this I told you. Okay. Now there are some exceptions to this. So that is the Article 361, which deals with the president and the governor. Some of the immunities have been given to them. Okay. So whatever they do, okay, in their official capacity, whatever duty they are performing, they are not answerable to any court. Similarly, whenever they are in their office, no criminal proceedings shall be instituted against them, and no process of arrest or imprisonment should be made during their tenure. Okay, and no civil proceedings should be instituted against them during their term of office until the expiration of 2 months of notice. Okay, if you have to start some civil proceedings against them, you have to give the 2 months notice. After the 2 months you can, okay, but in case of criminal you cannot. No notice, no criminal proceedings. Okay, then the second thing is, if you are a media person and you are going for publication of any newspaper or any report, but this should be true and it should be very much legal, okay, then nobody can prosecute you under the civil and criminal proceedings. Okay, this is article 361. Then 105 and 194, and these are the parliamentary privileges that we will do in parliament chapter. So no MP or no MLA will be liable to any proceedings in any court. Whatever they do in their official capacity in the parliament or in the state legislature, they will not be liable for any whatever they do under Article 105 and Article 194. ठीक है? उसके बाद this again we will do in detail, but a little bit is given here that under Article 31C. ठीक है? 31C says that 39B and C, 39 clause B and clause C are sort of superior over Article 14. So if you have to implement 39B and C, we will see what B and C is in the Jkpscs. If you have to implement 39B and C, okay, you can violate Article 14. This is given in Article 31C. Okay, and Supreme Court says that where 31C comes in, Article 14 goes out. That means in this particular case, Jkpsc has been given a little bit of advantage over the fundamental right, that is Article 14. Simple. Then we have the foreigners in the embassies, है ना, the ambassadors, the diplomats, etc. They enjoy the immunity here, है ना, from criminal and civil proceedings. So whatever they do in their official capacity, they will not be called for that. Or the UN or their employees here, they also enjoy the diplomatic immunity. So this is just the exceptions to Article 14. Why? Because the fundamental rights are not permanent. These are not absolute. Okay, there are some reasonable restrictions or there are some exceptions. Then you have the Article 15, prohibition of discrimination on certain grounds. Okay, 15 simply you have to remember two things. Okay, 15 clause 1, 15 clause 2. These are the fundamental rights. The rest are then the exceptions. Okay, so these two, that is firstly, state, you have to cram these titles, है ना? You have to cram this. There is no other option. So state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth. This you have to remember. Religion, race, caste, sex, place of birth. You cannot forget any of these. You should know these 5 are there in Article 15. Okay. Then this discrimination on only is important because only connotes that discrimination on other ground is not prohibited. Only on these 5 grounds it is prohibited. But if there is some other ground that government feels that we need to, like we will see here, है ना, if you are, so here sex is given, है ना, but government is coming up with some affirmative action for women, so there it changes. Okay, but usually you cannot discriminate. You can go for affirmative action if you feel that the this particular section of society is not represented adequately, then you can come up with some affirmative action, but you cannot discriminate. Okay, what is this is the clause 1. What is the clause 2? Clause 2 means that nobody will be discriminated on these 5 cases: religion, race, caste, sex, place of birth. With regard to access to shops, public restaurants, and hotels, nobody will be discriminated. You can go to any shop, you can go to any restaurant, any mall, any hotel, you can go to any tank, bathing ghat, wherever you want. Okay, this provision prohibits both the state and the private individual. Why? Because if I am a person, see, this is for the state. This is for the state, clause 1. Why? Because the state will not discriminate on the basis of religion, race, this and that. But here, if I am a person, if I am a shopkeeper and some particular section, some particular race or some particular sex, caste is coming to me for the purchase of some items, okay, I cannot discriminate. That is why this private word is written. Okay, so that is why it is said that the this clause 2, both the state and private individuals, they have to follow the Article 15, while as the clause 1, only the state has to, because we cannot discriminate on the basis of this because we don't have that much this. For example, in case of educational background or in case of employment, there the state should not. Okay, here the word state is mentioned, but in clause 2, nobody can, neither state nor any private individual. Now there are some exceptions. What are the exceptions? Some affirmative action has been kept for these particular sections of population. You should be knowing. Clause 3 deals with the women and children. You can go for any reservation or for midday meal scheme or a right to education for children. You can come up with all these things for their upliftment. Then clause 4 deals with the socially and educationally backward classes, SC and ST. Okay. Clause 5 deals with the socially and educationally backward classes and their admission to the education societies. Okay. It is for the this is for socially and educational backward, SC and ST, and their reservation of seats in and fee concession in the educational institution. This deals particularly with the SCBCs, okay, socially and educationally backward classes. Here it is SC and ST also. Then, but there is some exception that minority institutions cannot be forced because they have been given the 29 article is there, 30 article is there. They have been given some immunity. They can, limit their admissions to. We will leave that separately to 50%. Okay, they have the as per some Supreme Court judgment. Okay, we will see that they can not they cannot allow it's their discretion that they can stop the after 50%. They can till 50% they can fill their own minority students, and after 50% they can entertain the outsiders also. I mean the people from other sections, not from the minority. So this is the exception. Okay, then there is Article 15 Clause 6. It talks about the EWS. Everybody knows this. Okay, which Amendment Act is this? Okay, just type in the comment. I'll comment section. I'll check later. Okay, just type the Amendment Act. So 10% of the seats are reserved for them in the educational institutions. Okay, including the private, aided or unaided, whatever, except again the minority education institutions. Okay, this was a recent amendment. So there was some OBCs were given the 27% of the quota. Okay, why? Because this 15 clause 5. What was the 15 clause 5? The for SEBCs. If you want to give, because this is the exception to Article 15, so you can give some of the this privilege to them. Special provision can be made. So to give effect to that, this particular C section was added under the 93rd Amendment Act. Okay, so 27% of the quota was reserved for them for the OBCs, but the court directed to the central government that there should be the concept of creamy layer that should be applied to the OBCs. Okay, this is not for SC/ST. This is only for the OBCs. So who are the creamy layer? You can see those who have the constitutional post. Obviously, president cannot enjoy OBC, or their children or etc. Similarly, the judges, chairman, this and that. Similarly, those Group A, Group B officers. Then in army, the colonel and the above rank. Then professionals like doctors, lawyers, etc. Or person having some particular agricultural land above some limit. Okay, or those having the annual income more than 8 lakh. This is the general criteria. Then there was this Amendment Act that I was talking about, 103rd. Okay, it after this Amendment Act, this order was made giving the 10% reservation to EWS. Okay, and this is the criteria that their income should be below 8 lakh. Okay, and this is the that you have to that you should know at least that this should be the agricultural land. Okay, this should be the residential plot. This, if you are in the notified municipality, this should be the this area. If you are not in the notified municipality, then this should be the area. These are the general things. Then your property would be clubbed here, there, and there. It will be clubbed, and then it will be seen. And then your parents, siblings, all these will be again clubbed, and the property criteria will be seen. Okay, this is the general thing that you know. Then is the equality of opportunity in public employment. That is Article 16. Again, we have so many clauses. So 1 and 2 are in the rights, rest are the exceptions. So what is the right? Equality of opportunity to all citizens in matters of employment. Okay, under the state. So this is only for the public employment. Okay. So here one criteria will be added. religion, race, caste, sex, place of birth plus descent is added. Okay. 15, in 15 we didn't have descent, in 16 we have descent also, apart from these 5 that were already there. So this is important for prelims, you should be knowing. So this is article 16, that state shall not discriminate, and this is 16 clause 2. Okay, on only on the basis of religion, race, caste, sex, descent, place of birth. Okay, nobody can be discriminated. Then these are the 4 exceptions. What is the exception? That parliament can, who? Parliament, you should be knowing. Parliament can prescribe residence. So parliament can prescribe residence as a condition. Okay, you can go for the you can prescribe residence for some of the public employment as was made in this, but it expired later, and now currently we have only the Andhra Pradesh and the Telangana having this residence criteria. Secondly, for the upliftment of the backward classes, if they are not adequately represented, state can make some reservation. Then 15 clause 5, again, if your state can come up with a law for a particular religion. For example, there is some suppose Sabarimala temple is there. Okay, so there is some board governing the day-to-day activities of that. So a particular religion can be made eligible for that, for the post of the board. Aisa nahi hai ki some other religion will come, Muslim, Christian, Sikh, etc. They cannot, because this is for a particular reason, particular religion. So that law we can bring in, no problem with that. Then again, this EWS that I told you already, 10%. Okay, then there was this Mandal Commission. It was again to see whether 27% should be there for the OBCs. Okay, so there were so many things. This was the second backward class commission. Please type the first backward class commission. If anybody is from Anthro batch, then they should be knowing. Okay, if anybody is from Anthro batch, please type. Okay, Rohit has written. Okay, Kalelkar. Okay, then that was the first. Now this was the second Mandal Commission. Then this is actually done under Article 340, that this commission will be appointed. Okay, this was the second, and they had to check the conditions of the socially and educationally backward classes, and then they gave the report in 1980. Then all these classes were categorized into socially and educationally backward classes, and which was constituting almost 52% of the population. Okay, that means 52% of the population were falling within the meaning of the socially and educationally backward classes, excluding SC and ST. So they were already there, है ना? So 8% and 16% are there, then 52%, and there remains nothing. Okay. So then commission recommended for 27% of the reservation for OBCs. Then, and said that the total should amount to 50%. Okay. Then VP Singh government came and upheld this. And VP Singh government at that time had said that 10% will be given to EWS, but that was not then done later. Okay, this was not accepted. Only this 27% criteria was accepted. Okay, then there was Mandal case or the Indrasani case on this. Okay, this examined this and it upheld the constitutional validity of 27%. But there was some condition, like you should not belong to the creamy layer, and it should be only for the initial appointment. It cannot be for promotions. For promotions, we have reservation only in case of SC and ST. For OBC, we don't have reservation in promotions. Okay, then your total this quota should not exceed 50%. Okay, and carry forward rule should be there. That means if suppose what is the backlog vacancy is that if we have OBC, for OBC we have 27% criteria. Okay, then if the 27% is not filled, suppose only few posts are filled, rest of the posts are vacant. Now these posts will be added to the next year. Okay, that will be called as a carry forward rule. But again, it should not violate the 50% criteria. Okay, if it is exceeding 50%, then we will not add. If it is not exceeding 50%, then only we will add the backlog vacancies to the next year. Then there should be the statutory commission who should examine the complaints, if any complaints are there. Then government take following steps on the basis of this Mandal Commission. So this was the Ram Nandan committee. It identified the creamy layer. Okay, then there was this NCBC created by the Act of Parliament. Okay, to look after the this complaints of this, to give effect to this point. This particular NCBC was created, and then recently under Amendment Act 102, this was conferred the constitutional status. Earlier, it was only the statutory body. Now it is the constitution body. Okay. And this is the article which is inserted, 338B. Okay. This you already know. So, since in the Sani case or the Mandal case had said that there should be only in initial appointments the reservation should be given, not to the promotions. But then to give effect to that, 77 Amendment Act was made, so this promotion was nullified. Okay, but there was this another provisions added to the Article 16, that is the 64A. Why? Because promotions, reservation in promotion for SC and ST will be there. It will not be nullified. Only in case of OBC it will be nullified. And 85th Amendment Act provided the consequential seniority. What is consequential seniority? That if suppose there is some a person belonging to SC and ST and some general category person, okay, after 5 years or 10 years, who will be promoted? The person from SC and ST. Why? Because they will be considered as senior compared to the general category person. So that is called as a consequential seniority. Even if they were appointed the same year, still they will be considered as senior, okay, because of some consequences. What were the consequences? They were from SC and ST, and because of the historical injustices, this particular provision has been kept under under 85th Amendment Act. Okay. So then there was 81st Amendment Act. Okay, it was with regard to the backlog vacancies. Since earlier it was said that you can add the backlog vacancies, but it should not cross the 50% of the ceiling. But now after 81st Amendment Act, it was said that it ended the 50% ceiling or reservation. So now even if it is breaking the 50% ceiling, no problem, you can add the backlog vacancies. Okay, this was under 81st Amendment Act. Okay. Then with respect to Tamil Nadu, there is some special provision, that is the 60% of the 69% reservation is provided, okay, which is exceeding the 50%. So why this is there? Because this has been put in the 9th schedule. This we will do later what 9th schedule is, and why this has not been changed till now. So this Amendment Act, 76 Amendment Act 1994, placed the Tamil Nadu Reservation Act of 1994 in the 9th schedule, and hence they are giving the 69% reservation to their local population, and which is exceeding 50%. This is still sub judice. This is within the this is yet to be decided by the Supreme Court whether this should be continued or not. Okay, it's pending. So there was a issue also at the time of need, okay, because that was again they had to give certain percent to the people from outside, because we have the merit basis college allocation to the qualifiers. But since Tamil Nadu has kept 69% for its own people, so it was sort of in contravention to the need clause. So again, this is, I told you, this is sub judice. So let's see what Supreme Court decides on this. So again, this is written EWS 10% reservation, and these are all the exemptions that you cannot give EWS to those posts which are scientific or technical, because there you need only the merit. Okay. And the group A officers, those are also exempted from EWS category. And some scientific or technical posts are there, or somebody is conducting research in some particular organization, there also EWS will not be applicable. Then is the abolition of untouchability. Okay, what is Article 17? Everybody knows what untouchability is. Okay, this is not, just remember, this is not mentioned in the Constitution. Sorry, this is not defined in the Constitution. The term untouchability is not defined. Okay, only the Article 17 says that the untouchability is forbidden. Okay, nobody can practice it. Now, what untouchability is, that is not defined. And then you have this Untouchability Act 1955, and I told you SC/ST Prevention of Atrocities Act. This was amended in 2015, and it was made more stringent. These are there. Okay. So I told you this is not defined in the Constitution, and Mysore High Court has said that Article 17 is not held that the subject matter of Article 17 is not untouchability in the literal or the grammatical sense. It's not grammatically untouchability. You are not touching somebody. It's not that. Okay. It means the social disabilities. Disability in the sense that you're not allowing a particular person to your shop, you're not allowing anybody to enter the mall or to take water from the well, things like that. The social disabilities that have been prevalent since ancient time, Only those are considered to be untouchability, not the literal untouchability. You are not touching anybody, okay? But it does not cover the social boycott of 5 individuals. There could be boycott within the society on some particular criteria. That boycott will not be considered the untouchability, okay? Then Supreme Court has held that this is against the private individual also. Okay, so this is not only against the state, but against the private individual also. Then there is abolition of titles, Article 18. So what is Article 18? Simply you cannot give yourself to some title, like we had the Rai, Bahadur, Raja, Maharaja. So this is not continued now. But if there is some military distinction or some academic distinction, that is fine, that you can. Okay, rest of the titles are forbidden. And if you are a citizen of India, you cannot accept any title from outside also. Okay, some foreign nation cannot give you some title. Okay, titles are totally not entertained. These are under Article 18. These are completely abolished. But awards like Nishane Pakistan, so there were so many. Even the prime ministers, the erstwhile prime ministers were also given Nishane Pakistan. That is just the award. That is not the title. Okay, that is allowed. Then if there is any foreigner holding some this office within the government, okay, or some office of profit that we say, okay, so they also cannot accept any of the this title from outside without the consent of the president. Even if they are not the Indian citizens, even if they are the foreigners, they cannot unless the president gives them the consent. This is so as to ensure their loyalty. That is the reason why we are keeping them within India, because these are loyal to the Indian constitution. Then again, no citizen whosoever or foreigner, citizen or foreigner, if they are holding any office of profit, okay, they will not be entitled to accept any present emolument, whatever, okay, without the consent of the president. So this is under the Article 18. So here you have to take care of two things only. That is only the hereditary titles of nobility, that is the Maharaja that I told you, these are banned, okay, not the national awards. These were for some time these were also struck off by the government, okay, because these were confused to be the titles. But then later on these were revived by the Indira Gandhi government. They said, Indira Gandhi said that these are not the titles, we are just recognizing the distinguished service if anybody has rendered to the nation. That is okay, we can give the award, for example Bharat Ratna, this and that, okay, this still continues, and Balaji Raghavan case again has upheld it, that it's okay, we can give these awards. But again, you cannot use it as a prefix or suffix, that will not be entertained, but you can give the award. Okay, so this is it from Article 18. It's 9:22. What should we do? Should we continue or what, or shall I take the doubts now? Please write in the comment section. Okay, some are saying tomorrow, some are saying go ahead. Please continue. Okay, tomorrow. So it's like 2-2 tomorrow. Okay, majority are with tomorrow. Ayushi, are you there in the class? Ayushi?
Yeah, I'm here.
So what do you suggest?
हाँ ठीक है. Are you taking doubts अभी?